permitted to mention one urgent, my lord. The matter is running before your lordship at 307. The urgency is, my lord, the sanction plan was rejected in the month of March 2025. Before your lordship, I have filed and one writ petition. At the time of hearing, they have placed the rejection order on 10th September. Your lordship give me liberty to file the same. I have filed it. The matter is 309, my lord. I have, my lord, spent huge money for purpose of building residential house, my lord.
Give us slip. We'll see.
May I have lordship's kindly to mention item number 315 of today's list for upgradation, my lord. The urgency is this, my lord. In front of my premises, my lord, the respondent municipal corporation is constructing, my lord, one garbage disposal vat, my lord.
Give
That-
us slip.
my lord. Grateful, my lord.
To mention, my lord, I'm praying for reliefs in terms of similar order passed in another application in the writ petition, my lord, where the property has been, possession of the property is taken by KMC, but my goods are inside the property. My lord had granted me liberty to include this matter in the list, but lordship, unless it comes under the heading of urgent motion or to be mentioned, my lord, it is not likely to be taken up. If lordship can hear it before the vacation for a small direction in terms of the other
What are
application.
your goods?
My lord, it is lying inside the property and the entire
What are the
my lord, trucks. My lord, it's parked inside. My lord, I had filed my application, my lord, 2 months ago. My lord, it has not come in the list. But I'm praying it be taken up before vacation in terms of the same order, my lord.
Paying
Grateful, lordship.
a lordship leave to file this application on urgent basis of lordship. Urgency is that lordship, the notice under section 401 was issued against me, which was subsequently withdrawn. On 5/8/2024, again a notice of 401 was issued. I filed a petition challenging that. Now lordship on 18/9/2025, the respondent municipal corporation has issued notice under section 400 subsection 1 of the Kolkata Municipal Corporation Act 1980, making the learned advocate and regard as person responsible for carrying on the unauthorized construction, lordship.
It's your house.
Not my house, lordship. It's a petitioner's house, lordship. They have issued notice against me that I am the person responsible carrying on the unauthorized construction. There is no unauthorized
List it
construction,
on
no
Friday.
inspection.
List it on Friday.
Lordship, I am on this. Can application. I filed the writ petition. It is appearing as item number 260. I filed the can application annexing the for setting aside the order dated 18/9/2025. Like
Writ petition is already there, right?
writ petition is there, lordship, but 18/9/2025, that subsequent order which has been passed by the Kolkata Municipal Corporation, I have challenged that in this can application.
How can you challenge that? Why don't you file a writ petition?
Lordship, writ
How
petition is
can you
pending.
challenge a substantial?
Writ petition is
there is
pending. No, writ petition is pending before lordship, challenging the 401 notice, lordship. Subsequently on 401, lordship, they have served now
401 notice on which property?
my petitioner's property, same property which has been challenged before, lordship. In respect of that property, only 400 subsection 1 notice has been served.
You file it, we'll see it. Make a mention for the main writ petition, we'll see it.
Lordship, kindly takes us the matter on Friday, lordship. Otherwise,
No, no,
lordship,
nothing.
any day, lordship, they will come and they will start demolishing.
What,
Lordship.
it's
Notice
not
has
your property. It's notice is given to the it's petitioner's property, right?
Notice is given to me, lordship. This
That's all right. They can't demolish anything. Give it back to him.
under my name, lordship, it is given, lordship.
We'll see that. Mention the writ petition. We'll see it. You file it in the registry. It will let it come in due course.
Lordship, kindly before vacation, lordship. Otherwise, lordship, they will any day they will come and they are saying that.
Sir, it's not your property.
Lordship. No,
All right.
lordship.
So let them demolish whatever they have to demolish. Yes.
May I be allowed to take a leave, lordship, to file the affidavit in reply, which is notarized, lordship, because the petitioner has undergone a very big surgery. He cannot come to court, lordship. The matter is fixed on November, lordship, but then also he will not be able to come, lordship. May I be allowed to file this affidavit in reply, which is notarized, lordship?
No, madam, this can't be done. This can't be done. Notarized affidavit. What has happened to the petitioner?
He has gone a surgery, abdominal surgery, lordship.
Surgery, people go surgery. It's not that nobody goes through surgery.
Lordship, but he has been advised
We'll
to
see it
take
in
bed
November.
rest, lordship.
We'll see it in November. Not like this.
Without lordship's leave,
November, madam, not now. I'm not allowing it.
lordship, as your lordship.
Follow out the list.
Lordship, this is my writ petition, my lord. I have instructions to withdraw this writ petition, my lord. This is
This petition has been filed into wrong forum, my lord, and seeking the appropriate forum in accordance with law.
Petitioner seeks to withdraw the present writ petition with liberty to pursue his remedies in accordance with law. Writ petition is dismissed as withdrawn.
Lordship, I have given the instructions, my lord, which I
The instruction is kept on record.
for this. Written open.
I am appealing for the petitioner, my lord. The dispute has already been settled, my lord. That's why I am withdrawing this writ petition.
What do you mean dispute settled? You are alleging unauthorized construction.
No, no, my lord, I have received one instruction from my client, my lord,
Yes.
and that has already been annexed. in
Sir,
the-
what is the writ petition about? Unauthorized construction?
Yes, yes.
How can this be settled? How is this settled? By taking money?
No, no, no.
Then what happened to the unauthorized construction? They have taken action.
Yes.
Where is the action taken report? I'll not allow you to withdraw this. Where is the action taken report by the corporation?
Robi Boni.
What is this?
It's a report from the chairman. There will be a operational meeting between the parties. There will be a step taken by the municipality on behalf of the action will taken by them.
Can a demolition action be settled?
Upon hearing of both the parties.
What is it written here?
Next date has been fixed for a hearing of the both party.
Hearing.
Hearing
It's a hearing notice.
notice, yes, Lordship.
I will not allow you to withdraw this. Learned counsel for the petitioner has filed the present writ petition seeking demolition
এই তোমার এটা কারেন্ট রিপোর্ট নয় তো
কোনো রিপোর্ট
ফেব্রুয়ারি মাসে তো
হিয়ারিং রিপোর্ট হবে
এটা তো 24
আরে এটা 24-এর তো my lord, kindly see the report, my lord. The date was fixed on November 19, 2024.
Yes,
This is not the current report, my lord.
I'm not looking at the current
I will
report.
bring a
What
fresh
is the settlement? You tell me what is the settlement between the parties?
Construction has already been demolished, my lord.
Fresh report দিতে পারি।
Where is that report?
Current report has not.
I will bring the fresh report on the next day, Lordship.
Are you sure construction has been
Yes,
demolished?
yes, my lord.
Inspection करें.
The current report not.
Learned counsel for the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn.
Great, my lord.
ये तो वापस कर. You will not use this forum for settlement.
Item number 3, I am for the petitioner. I have written instruction from the petitioner to withdraw this matter with a liberty to file afresh.
My lord, in this
Lordship.
matter, my lord, I am appealing for the corporation, my lord.
Yes.
The second round of litigation.
Third item, Poishali Dotto.
Yes.
Lordship, certain respondents has to be added in the writ petition, Lordship. That's why the request has been made by the writ petitioner to withdraw this matter with a liberty to file afresh. I'll be filing the writ petition afresh in accordance with law, Lordship.
You can add the other respondents here in this
Lordship,
petition
certain
also.
facts are also required to be placed before.
What are those facts? It's a demolition you're asking for?
Yes, Lordship. I am the complainant here.
You're the complainant.
Yes, Lordship.
How many writ petitions you have filed in this court?
Lordship, I have instructions about only this writ petition.
File an affidavit, how many writ petitions you have filed. Don't use this forum to settle your personal
Lordship, there's no-
vendettas.
Lordship will be filing another writ petition, Lordship, only for only by adding the respondent.
You can add
appropriate
the respondent here also.
Yes, Lordship.
You can add the respondent here also.
Lordship, I can, but there is one pro forma respondents mentioned in this writ petition that has to be recorded as respondents in the normal.
Add them. I'll give you the liberty to make the correction.
And certain facts are also be required to be brought because there are certain RTA applications which has been filed and obtained from the KMC authorities in course of this writ
See,
petition.
either your matter is the demolition has taken place.
No,
It has
Lordship,
not.
it has not taken place. We have got the information that 401 notice has been sent to the private respondents. However, no action has been taken by the KMC authorities, and we have obtained that through an RTI. So we have those RTI copies which we have to place
Yes.
before your Lordship.
Madam, Mr. Alok Kumar Kushi is appearing, but he could not leave the house, my lord, due to water logging, my lord. Can you visit on any day?
He wants to withdraw it.
My lord, Mr. Ghosh is appearing. in-
I'll file afresh.
Try to-
Learned counsel of petition seeks to withdraw the present writ petition with liberty to file appropriate proceedings in accordance with law.
Deeply.
And is granted liberty to file appropriate proceedings in accordance with law.
Well, I am for the petition.
Yes.
Well, in this matter, my lord,
My lord, I am appearing for the respondent.
well, this is not a demolition case. I was the adjacent premises owner, and while carrying on the multi-story buildings construction at the adjacent premises, there was several damages caused to my premises. I made a writ petition. Writ court ordered that upon the private respondent, not upon the government, you pay the amount of the so far the amount of compensation, so far the damage is concerned. Thereafter, this petition was filed. Nobody till date appeared. Today, first day, my learned friends are appearing. In the meantime, the developer promoter assured that he has taken all responsibility for carrying out the damages, repairing of the damages, and the matter has been settled. So nothing is,
Is the construction legal?
my lord.
Who appears?
Now construction, I have given no objection to the
Who
corporation.
are you to give no objection?
No, I have informed.
What happened in this?
I have
You to give no
no,
objection?
no, now not that respect. I have given that the matter has been settled. I have.
How is it settled?
It is.
Is
not,
there any unauthorized construction in the property or not?
No, it was not. That is why.
Let them file a report. I will not allow you to withdraw.
No, it is not a case of unauthorized construction.
What is it?
That is why. When the adjacent premises, in the adjacent premises, the construction was going on for a multi-story building. Because of this construction, my premises got damaged. That is why writ court ordered that upon the private respondent, developer, promoter, you take responsibility of repairing that.
Show me the order.
Yes.
Restriction was given to the corporation.
Are Baba,
Precisely as
Show
per
the order.
damage and
Hey,
estimate
hey.
the cost of restoration.
দাঁড়াও একটু দাঁড়াও my lord, all these things are not represented properly. I am bound to say, my lord, kindly come to page 39. My lord, what can I do in the monsoon? Page 39. My lord, kindly
Read page 5, para 5.
para 5. My lord, all these things, my lord,
Please read page 5, para 5.
where is the service the private respondent, illegal construction. My lord, this is not the case without the following the building rules
Sir,
and norms.
Who has written this? What do you mean this is not the case?
Kindly understand, my lord. This was an earlier writ petition.
What do you mean this is not the case?
Kindly,
Who has drafted it?
my lord, kindly, my lord, hear me. My
Is your pleading or not?
lord, kindly hear me, my lord, kindly, for a moment, my lord. I am apologize.
Do not use this court as a ground to settle your disputes and make money out of it.
Not for,
All these illegal constructions, you try to extort money from the developers.
please, my lord, kindly allow me.
Don't use this extortion tactics.
Kindly allow me, my lord. Kindly allow me.
Who has stated this?
My lord, the
Para 5, read it.
my lord, earlier petition, my lord, was filed, another writ petition.
Sir, can you read page 5, para 5?
I have seen. It is wrongly drafted.
What does it say?
My lord, it is wrongly drafted, my lord. I am
Wrongly drafted?
I am not pressing that paragraph, my lord. I am not pressing. That is not the case.
This
Okay.
court will press that paragraph. Suo moto, I'll send your client to jail.
My lord, kindly, my
You
lord.
wait and watch.
Kindly, my lord. Kindly, bear me, my lord. For kindly see the.
Dare you use this forum to settle your personal
Not it, not for because my learned friend, my lord.
learned friend?
No,
You
my
file
lord.
cases against your.
It is not a case of unauthorized construction. That can I say,
This is what you have stated.
my lord. That is wrongly drafted.
Wrongly drafted? You'll take the court for a ride?
No, my lord. I apologize, my lord. I personally apologize. For
Who has sought the affidavit? Then I'll send the person to jail.
no, my lord. Kindly,
340 should be started against him.
No, kindly, my lord. It is not this case, my lord.
Who's this lawyer who has drafted it?
My lord, kindly, my lord. Excuse me, my lord. Excuse me.
Sir,
I took the
Please
responsibility.
don't take this court for a ride.
No, it is not a case of unauthorized construction. Kindly see the order, my lord, in the writ
This is
petition.
your pleading.
I apologize, my lord. Kindly see the.
Don't apologize. Answer the pleading.
Some private respondent started once it was alleged, but my lord, the main contention is that kindly see the order, my lord. Order, my lord. Kindly see. I am not pressing on this point, my lord. Kindly see the order, my lord.
Sir,
For-
I'm not concerned whether you're pressing this point or not.
I know, my lord. I know the difficulty, my lord. Kindly.
And Mr. What is your name? I'll record submissions against you. And I'll refer you to Bar Council for filing these kind of frivolous cases and trying to extort money on behalf of your client. You seem to be a senior lawyer.
My lord, I apologize personally, my lord. Excuse me, my
Your apology is not going to be helpful for this court.
my lord. Kindly allow me to show one page, my lord, of the order.
Show it.
Yes, ma'am. Kindly, my lord. 51. 1339 is the my lord, or was the order.
File these petitions to extort money.
No, my
Nothing
lord.
else.
No, my lord. No, my lord. My lord,
And
page,
file a civil suit if there's any damage. Why did you file a writ petition?
my lord, kindly, my lord, see the order, my lord, of the earlier coordinate bench. That is the whole case, my lord. That is the whole case. My lord, kindly see that the entire
Which
order,
page?
paragraph 39 onwards, I am reading, my lord.
Page.
Page 39. Kindly see. What was the cause of this matter? My lord, may I read, my lord?
Yes.
My lord, the petitioner raises the grievances that the respondent number 10, a developer, has undertaken the construction of the holding number 270, ward number 7, under Chandanagar. The petitioner contends that this construction has caused significant damage. This was a damage to the residential building situated at the same holding number. The damage extended to both the buildings itself and the common passage. The learned advocate representing the corporation acknowledges that upon inspection, the corporation found that the construction at plot number 270 had indeed, it is my adjacent plot. My plot number is 267, caused damage to the petitioner's residential premises. In response to this, corporation issued a stop work notice to the respondent 10. Subsequently, parties were called for a meeting. During the meeting, the petitioner gave his no objection to the continuation of the construction contingent upon the assurance that the respondent number 9 and 10, their private respondent, a developer promoter and the owner would undertake the necessary repair work for the petitioner's residential building and ensure that no further damage would be caused. But on this understanding, the respondent number 9 and 10 were permitted to continue with the construction work. However, the learned advocate for the petitioner alleges that despite the assurance provided by the respondent number 9 and 10, no remedial measures have been taken. No repairs have been carried out on the petitioner's residential premises. But this is not an unauthorized. My premises were damaged. The petitioner further expresses concern that if the respondent number 9 and 10 are allowed to proceed with the construction, the building will suffer additional damage. In the light of the aforesaid foregoing, the petitioner is disposed of with the following direction. Corporation shall appoint a competent engineer who will oversee the necessary repair work at the residential building to be undertaken by the petitioner. The engineer appointed by the corporation provide a detailed estimate for the repair works, and the petitioner shall proceed with the repair works in accordance with the estimate. The estimate shall be prepared within 2 weeks from the date. These respondent number 9 and 10, the private respondent shall deposit the money as per the estimate made by the engineer of the Chandranagore Corporation. The petitioner shall be entitled to receive the cost incurred for the repair works from the deposit made by the respondent 9 and 10. It was the spirit of the order that 9 and 10 will deposit money as per the estimate of the engineer of the corporation. That order has been communicated several times. My lord, kindly see my representation. No action has been taken. Third, or next page number 63, I communicated the order to all the authorities of the municipal corporation to estimate, give an estimate, they did not do. Thereafter, my lord, page number 63 is the first, my lord. Thereafter, again, my lord, 67. I've informed all the authorities. Thereafter, my lord, I have informed the order, you have to estimate, seeking the corporation's engineer to estimate. No reply taken. In the meantime, my lord, monsoon started.
Writ petition filed for recovery.
Repair, my lord. Repair. Actually, that is I got a change brief. Initially, the lawyer who drafted, then I made a supplementary affidavit to that petition, that it is not the case of unauthorized construction. It is a case.
Is writ petition entertained?
That is the problem, madam. That is the whole problem. But somehow court graciously, sometimes equitable relief was exercised, nothing else. And the persons amicably settled. The contending parties is, contending parties are private respondent and the writ petitioner. That is settled, nothing else.
Still there is a suppression. He has said
Hey,
corporation has
don't try to complicate situation. You hire, you say suppression. You have not exercised your power. I have lost my soul from the shoe.
What is your report?
Well, come to page 61. He has
Don't do that.
What is your report?
to your lordship's honor.
Please.
This was given in
Ye.
pursuant to the order, solemn order passed by the coordinate bench of this court, my lord.
After
We are
that-
sending two options.
Just a minute.
Yes, sir. After assessing the damage by a engineer of the competent engineer, structural engineer, my lord, he has given two options, my lord, A and B, in page 61, my lord.
I will answer to that.
Option A and option B. In against to that, my lord, he has said neither option A is acceptable, neither option B was acceptable. But no option 3 has been proposed, my lord. We are expecting an answer. Then he filed this writ petition, and now he is
No.
claiming that it has been settled.
My lord, my answer to that, my lord, the court directed them to estimate the cost of repair. They are giving me alternative, nothing else.
Dismiss.
Kindly,
Learned
my lord.
counsel, the petition seeks to
Right.
withdraw the present writ petition, dismissed and withdrawn.
Gratefully, lordship. Gratefully, lordship. My lord, sorry for my submission, my lord, your lordships got it.
How, I don't know how these writ petitions are
And
entertained.
this is not a case for money extortion. Really, I
This is absolutely your damages. You file,
that is
suits are filed for damages,
I-
where you
you're-
file writ petition for damages.
you're right, lordship rightly appreciated. Some advocate, he drafted and filed it.
How can you file a
Then-
writ petition
then
for
I-
claiming damages?
Then I got the brief and I was no objection taken by my learned friend. And that is why, my lord, court, I made the same submission. It is not a case of unauthorized cost. Much.
Please.
Lordship, I am for the petitioner. They were
Yes.
trying to open a party office on 15th of September by converting a parking area to a party office. So after filing this writ petition, the police authorities and everyone has taken action. And I am the petitioner. I was the school just opposite to the school in a residential building just below that. In the parking space, they were about to do that. They have stopped it.
Learned counsel, the petition seeks to withdraw the present writ petition. The same is dismissed as withdrawn.
Great.
মেল করেছি অ্যাডভোকেট অন রেকর্ড
Yes, Mr. Nag. Yes.
my lord, last occasion, my lord, on Monday, my lord had been pleased to keep it today so that we can file the evidence in opposition. We have served the unaffirmed soft copy to the petitioners, my lord, because yesterday we could not affirm.
Yesterday, they sent the, my learned friend submitted that yesterday sent the mail
Yeah.
But yesterday, my lord, this is the water logging, my lord, nobody come.
But we could not affirm, we are affirming it today. We will give a copy to everyone, hard copies.
Learned counsel for the,
Yeah, I have not received.
No, no, I will give today after affirmation.
he will take it. Learned counsel for the respondent, Bidhan Nagar Municipal.
Millard.
Bidhan Nagar Municipal Corporation, Mr. Nag submits that he will be filing his affidavit in opposition
Millard.
during the course of the day.
But we will affirming and give copies within, because filing Millard, then it will go in the department, it may be misplaced. I will file next day whenever it is.
Will get his, he'll be getting the affidavit in opposition affirmed
And served.
and served to the petitioner during the course of the day. Learned counsel for the petitioner seeks and is granted 2 weeks' time to file his affidavit. It's affidavit in opposition, right, Mr. Nag? Reply to the affidavit in opposition filed by the respondent BMC.
After the opening, my lord, 3 days after the opening.
Seeks 1 week time after reopening to file his affidavit in opposition. Reply.
And interim order, my lord, expiring, my lord.
Interim order granted earlier is extended further for a period of 8 weeks.
Lordship, I am suffering. I am the respondent number 8 and 9. Against me, this interim order has been passed.
Yes.
So I am having a sanction bill.
No, my lord, that's the.
We'll see that. They are filing their affidavit. We'll see that.
Lordship will kindly fix a date. then.
Sir, showing me our plot,
We'll see that.
another plot.
That is a subject matter of a civil.
Who did bullshit, already.
After puja vacation, 8 weeks will be
Very interesting case, your lordship will.
18th November.
18th November.
And interim order, my lord, extended up to
8 weeks, 19th November.
that, for 1 week, by the time, if the matter will be not listed, any of that, the matter 1 week time. will be.
11th November.
Till the end of November or earlier.
Lordship, he wants the interim order to continue and I will be
Millard, the matter is 11th November.
11th November,
Grateful to you.
interim order for 8 weeks or until further order, whichever is heard.
Millard.
deeply obliged.
Mr. Banerjee, you don't have to do much.
But Lord, it's my duty
Obliged.
to
Yes,
say
absolutely.
that I am appearing for the state in this.
And duly noted.
The state has a duty because he is saying that we are making construction or.
Sir, my duty is waiting. Subject to
We will
decision of
see
your
that. We will see that.
Lordship,
Let the affidavit.
The subject matter is a civil court, it is pending.
No.
No, don't say no,
Subject
no,
to-
no.
We'll see that.
Subject to any direction from your lordship. State is waiting.
How the councillor in ward number 21 and how the plan also sanctioned. And you will find that in another ward plan has been sanctioned.
Millard, whatever there is not in the pleadings, Millard will not allow him to submit.
Everything is coming
Obvious-
from the bar, not from the.
Anything,
Councillor, I did
Nothing
not
is
hear.
written in-
we are not concerned.
Allow
Suddenly-
others to avail because it's a.
Yes, yes. Obliged, Millard.
Grateful
Obliged.
to Puja Maharaj, happy for you, Lord, thank you.
To you.
In item number 8, I am appearing for the Kolkata Municipal Corporation. Well, on the last occasion, your lordship inquired from from my learned senior, Mr. Ghosh, what is the latest position of this case? My lord, we have given hearing, order has been passed. It is yet to be served because certain formalities are yet to be complied with
Like,
in the, like it has to be placed-
just a minute, sir. Yes.
like, my lord, it has to be placed before the MIC for necessary approval. Thereafter, if as and when the MIC approves the order, it will be served upon the petitioner. That is the latest position, my lord. It is yet to be placed before the MIC. And I have been assured by the department in the next MIC meeting, it will be placed.
But that also has been placed long back. It's almost 1 year.
My lord, that is
Yeah.
why I have requested the department to place it immediately the next available meeting of the MIC, my lord.
They are avoiding to
When is
act
the,
on the section 400 as per order of the Honorable Court.
when is the next MIC meeting?
My lord, it cannot be before the puja, it will be after the puja.
This delayed tactics is continuing, my lord, in spite of the order and for compliance by the corporation. They took the opportunity that the matter is out of list. And I made an application on that account. That corporation is delaying to take any steps according to the order of May 2024.
Sir, order has been passed by the special officer building. It is placed before the MIC. We will pass a direction that in the next meeting of the MIC,
My lord. Yes,
this
My lord,
should be considered.
I may be directed to serve a copy to know.
my lord.
She will give a copy of the report.
My lord, today I'm a bit handicapped because the rest of the instructions are lying with
On
Mr.
on
Ghosh.
every
I couldn't
occasion, my
come
lord, on every
to
occasion,
attend court today.
copy
I
is
shall serve
delayed.
it by tomorrow, my lord.
Copies is delayed.
I shall serve it by tomorrow.
On the earlier date, equally, your lordship kindly look at the order. They only bring only one copy for the bench. And the other side is kept in darkness.
Shall we keep it on Friday?
Yes, my lord.
Shall we keep it on Friday
If your lordship so pleases.
so that you can give a copy to him?
My lord.
Friday, not today, Friday. They'll give a copy to you on Friday.
My lord.
On.
I'm grateful, your lordship. Your lordship is keeping the report today.
No, we'll keep, you give it on Friday. I'll take it on record, give a copy to him.
My lord.
We can dispose it.
My lord, I'm grateful.
Nine, my lord, I appear on behalf of the petitioner. My lord, this is answering respondent, my lord, is the Baripur municipality. On the previous occasion, they were
Lordship has directed.
appearing for municipality. Press service, my lord, which we have done.
You are appearing for Mr. Sinha?
My lord, I am appearing for Baripur municipality, my lord.
Yes, he's appearing.
My lord, page 16 is my representation. My lord, strangely, my lord, what my instructions are, the Baripur municipality itself has encroached upon my land and is raising construction without any sanctioned plan. So, my lord, this is the case of unauthorized construction against the municipality itself. My lord, what I would just pray before your lordship is, my lord, consideration and disposal of, my lord, page 16, my representation in a time-bound manner.
What has taken you? This is what representation is of
My lord, page 16, my representation.
23. What has taken you 2 years to come?
My lord, this was, my lord, filed in 2023. After the representation, my lord, it was stopped. Now, my lord, again they have started recommence the constructions, my lord, which is why, my lord, we again took steps and, my lord, we had mentioned it, which we lordship had graciously allowed upgradation.
Where have you stated that it is being done on behest of the municipality?
My lord, para 5 of my representation, my lord, at page 17. And my lord, there is a corresponding pleading to that effect also in the writ petition.
All right. Yes, Mr. Sinha.
My lord, my instruction is that, my lord, we have purchased this from the original owner. The municipality has purchased the land and thereafter, my lord, they have made the construction. And now, my lord, one contradictory statement your lordship will find from their representation and from the writ petition. If your lordship kindly come to page 16, that is their representation, they have stated there that the writ petitioner along with their brothers are the absolute owners. And in the writ petition, he has said that he is the absolute owner. My case is that, my lord, I have purchased it from the original owner and I can produce the registered deed also. If your lordship require, we can produce that.
My lord, Page 16, my lord, is explained in para 4, my lord. My brothers died intestate, leaving behind no legal heirs. I was the sole legal heir. Now I am the absolute owner.
So you are saying that the municipality has purchased the land?
Yes, my lord. That is my instruction. We have purchased this land. We have the deed.
Let them file the report then.
My lord. Beautiful.
Take down. The petitioner has filed the present writ petition being aggrieved by the inaction of the respondent in not taking any action against the alleged illegal and unauthorized construction carried out by respondent number 2.
Well, respondent number 225, my lord.
Respondent number
24.
24.
Mainly, my lord, respond number 2. That is the municipality.
Carried out by respondent number 2 at the land having dag number 4739, Baraipur, South 24 Parganas. It is the case of the petitioner that he is the lawful owner of the above mentioned plot, full stop. However, without his permission, the respondent number 2 is carrying out illegal and unauthorized construction over the said land, full stop. Petitioner states that he had submitted a representation dated 26/9/2023, however, no action has been taken by the respondent authorities on his representation, full stop. Learned counsel for the respondent states that the said respondent number 2 to 4 states that the said land has been duly purchased by the respondent municipality, full stop. He seeks and is granted how much time?
2 weeks after the vacation.
4 weeks time.
4 weeks, my lord.
After 2 weeks after vacation to file his affidavit in opposition, reply to the same if any within 1 week thereafter, list after 8 weeks. Mr. Sinha, give me your mobile number in the chat box.
May I pray for one indulgence, my lord?
Yes.
If Mr. Sinha could also file the title deed along with
That's what he's going to do.
I'm grateful, my lord. If your lordship would kindly indicate that in the order, my lord.
वो जहाँ लिखा है ना, he states that he has duly purchased and seeks and is granted time to file the relevant sale deeds along with the affidavit in opposition.
I'm grateful, my lord.
How much from there?
19 November. My lord, I am appearing for the petitioner, my lord.
But I for the state.
Beg for the municipality. On the last occasion, lordship, we had communicated, my lord, there was a stay in connection with the civil division application, which was the demolition order was challenged, my lord. It has been dismissed, my lord, last week only. So, my lord, we would be complying the demolition order, my lord, within some time may be given. The festive, let the festive be over, my lord, in the month of November. Some time may be given. We will, my lord, comply the.
উনি তো বলছেন আমাকে দিতে অসুবিধা হবে
না আমার সেকেন্ড উইক করুক 24 তারিখে কোর্ট খুলবে অক্টোবরে খুলবে তো
অক্টোবরে লাস্টে খুলবে
24-এ ফার্স্ট উইক
পুলিশ হবে না
ফার্স্ট সেকেন্ড উইক করে দিচ্ছি না
আবার তোমার দিতে হবে নোটিশ সব দিতে হবে
হ্যাঁ
কে দিয়েছে না না আমি না তো অন্য
হ্যাঁ আমি আমি আগে লিখে দিই আমার ফোন নাম্বারটা লেখা আছে না
ফোন নাম্বার লিখতে হবে
ফোন নাম্বার মিউনিসিপ্যালিটির হলে করে রাখি সুবিধা
Learned counsel for the respondent municipality states that the appeal
that the revisional application challenging the demolition order
that the revision application challenging the demolition order
by the private
dated February 2023 has been, it has been dismissed.
Yes,
Dismissed.
on
Has been-
16th of September
On 16th of September.
has been dismissed on 16th of September
by this honorable court, my lord.
by this honorable court in
CO number in CO number
PO number 712 of
Of-
2024.
712 of
712
712 of 20
of 2024.
24.
2024.
24. Full stop. In view of the said development, learned counsel for the respondent municipality states that seeks and is granted 2 weeks time after vacation to file, 4 weeks time after vacation to file his action taken report in compliance of the demolition order dated 20th February.
Great.
Exception, if any, to the same within 1 week thereafter, list after 12 weeks.
কবে ডেট করলো?
12 weeks. মানে
17th December.
হ্যাঁ?
7th of December.
কত হয়েছে?
Great.
I'm good to.
হ্যাঁ,
হ্যাঁ।
for class one.
Do you want the action taken report or you want?
No, I am for the petitioner, my lord.
So that's what I'm saying. You
Yes.
want the action taken report or I can record the submission and dispose it off?
Accepted.
Dispose of করে না, নাহলে তো আবার contempt আছে।
Yes, yes.
Your lordship has peremptorily fixed the timing, we'll do it within that, and my lordship may dispose it off. Or
No, then I'll change it. Then I'll,
yes.
আজকে
Time.
discuss করবে?
করে দিলাম।
তাহলে condemn করতে হবে তো।
then I'll just record his submission that he'll take action in accordance with law as far as this is concerned. And in view of the same, nothing survives in the present writ petition. The order dated so and so shall be complied within a period of
4 weeks after vacation.
within a 4 weeks after vacation.
এই ভোরু
Gotcha.
chapter vacation 24 তারিখ করবে তো?
হয়ে যাবে নভেম্বর।
वहाँ ऊपर वाला सेम रहेगा.
এটা বলবো। ব্যাক করে এই দেশে পুলিশ পাবো না তো। রাজ্য কৌতুর এলাকা।
22. In view of the same, learned counsel for the respondent municipality states that they shall take they shall take demolition action in terms of the order dated February 2023 within a period of 8 weeks after puja. Full stop. In view of the said stand taken by the respondent municipality, nothing survives in the present writ petition. The respondent municipality shall be bound by the statement made before this court. The present writ petition is disposed of in the above terms.
Grateful, my lord. Yes, sir.
My lord, item number 11, my lord, Mrs. Megha Sarkar is appealing for the petitioner, my lord. Her clerk instructed me to pray for an adjournment, my lord, but because she couldn't come to the court as of now, my lord.
Proxy counsel so and so appears and states that the main arguing counsel Miss so and so is not available. He prays for a short adjournment. Let this matter be listed after vacation. After 8 weeks, after.
Now, my lord, it is practically solved. Now, there is a meeting.
I had full faith in you.
I'm getting from deep that. But unfortunately, when my lord,
If Mr. Banerjee is appearing,
when my lord will be in the apex court, I'll be there.
My lord, unfortunately, my lord, it is not as rosy as it looks, my lord. This is, my lord, what I was served. I have, my lord, submitted, my lord, my bills and documents, but then there has been no reply, my lord, that's forthcoming. There are no communication thereafter.
Kindly will look to this, my lord. The resolutions signed by mayor and deputy mayor, everyone. And subsequently, there is a message. No,
Have you seen this, madam?
No, my lord.
Tell your client not to be very greedy. Come back on Friday. We'll dismiss it.
And not only that, they are,
Whatever he gets, he should be grateful and thankful to you.
My lord, much obliged.
I told them that
Sir, Friday?
Friday, my lord, but Friday,
I'm just handing over a copy of this.
oh, yes. This is not for, I can actually also, this is department note. Again, there is some sort of.
See, there is
internal
nothing.
note.
That's all right, but there's nothing which is communicated to them. There has to be some
Yes,
communication.
kindly record the submissions. It may kindly be submitted to the honorable court that pending bills of local beer will be paid within 15 working days. I can assure you, losses. Kindly record it, mine. Do not dispose it. Kindly record it, mine.
Let me kindly keep it after vacation, my lord. Let them make the payment and let me come back.
No need, madam. After vacation, we don't know.
It's the communications and kindly record it, instruction to my
Learned counsel for the respondent, learned senior counsel for the respondent corporation, Mr. Banerjee, states that the corporation has agreed to release the payment in terms of the bill raised by the respondent. Full stop. A communication to this effect is handed over to this court and the same is kept on record.
Oh. And on that basis,
15 working days to mobile a message.
May I get
may
a copy,
kindly be
sir?
submitted to the honorable court that pending bills of local bus better will be within 15 working days. Hence,
Within 2 weeks.
50 working days.
Working days.
Within 2.
Vacation also, no?
Petitioner. Within 2 weeks.
Within 15 working days, my lord.
Within
Otherwise,
15 working days.
I'm grateful, deeply obliged. খাবড়াচ্ছে কোনো কিছু না হলে তো এখানে I'll come. I'll not spare them.
And that is why my lord kindly keeps it pending, my lord.
আবার pending.
No.
If you get a chance to file a contempt, no problem. I told them either you prefer an appeal. You have a right to prefer. If you do not prefer an appeal, you have to comply the court's order.
This court appreciates the efforts of the learned senior counsel in
I'm deeply grateful.
putting a quietus to the present litigation. With the above direction, the present writ petition is.
As your losses, man. So within 15 working days, we'll pay it. If it is not paid, I am here. No problem. I assure my friend.
Any interest?
No, madam, you are getting the money. You should be happy about it.
As your losses.
You would have got nothing here.
Page. No, no,
15
15 working days.
My lord, may I have a copy of this communication?
No
my lord?
need. The order is there for you.
Much obliged. It is disposed of.
Disposed of.
Very good. May I leave, my lord?
Thank you, sir.
Grateful.
My lord, I am for the,
Kolkata Municipal Corporation.
I'm appearing for the petitioner.
Report those.
Last topic and your lordship asks. The corporation, the hearing was done on 8th September, but my lord, no decision has yet been taken, my lord, as per instruction, my lord.
Why?
I have asked, my lord, but no decision has yet been taken, my lord. Last occasion, I have submitted my report, my lord.
So far as the state is concerned, Lord, your lordship has already received the
Work
report.
stop notice was issued. Hearing was conducted. Then what happened?
Decision has not yet been taken, my lord.
Why decision has not been taken?
As per, I have taken instruction, my lord, not yet been taken, my lord. Kindly keep it after vacation, my lord. In the meantime, they will.
Page 811.
Learned counsel for the respondent KMC
report দেওয়া আছে।
shall file further report indicating the outcome of the hearing which was conducted on 8/9/2025. Since no final order
24 তারিখ না?
has yet been passed. Full stop. Let the affidavit be filed. The report by way of an affidavit be filed, placing the final order on record within 2 weeks after vacation. Reply to the same, if any, within 1 week thereafter, list after 6 weeks.
1 week after vacation এর মধ্যে
Yes.
affidavit করে দিতে হবে ডিসিশনটা।
Anything?
আমরা the matter will appear
19th November.
19th November. I'm grateful to you.
Bless you, Lord.
Lord, how about the petition, my lord? Lord, this is my affidavit of service.
Yes.
Lord, this is the similar matter, my lord, moved, my lord, in earlier occasion, my lord, 16 matters, my lord, which have been fixed on 10th of, my lord, November, my lord. Miss, my lord, you had the husband of the petitioner, my lord, died, my lord.
Yes.
My lord, I have, my lord, missed my all the other orders, my lord, as passed in other matters, my lord. The similar order, actually, my lord, similar order.
The petitioner has preferred the present writ petition. Saurabh. The petitioner has preferred the present writ petition being aggrieved by the inaction of the respondent municipality in not releasing her deceased husband's retirement dues even after four years of his death. Full stop. It is the case of the petitioner that her husband joined the services of the respondent municipality in the year 1985. Full stop. He retired from the service on 26/7/2021.
Husband retired.
He retired.
Yes, sorry, sir.
Not she. I said he
Not she.
He retired from the services on 26/7/2021 and expired on the same date. Full stop. The respondent issued the PPO order on 21/2/2025. Full stop. As per the said pension payment order, the total gratuity amount was sanctioned was rupees 7,30,000 and the enhanced family pension was fixed at rupees 18,650 from 27 July 2021 to 26 July 2026, and normal family pension was fixed at the rate of rupees 11,190 from 27/7/2026. Full stop. The respondent municipality has been paying the monthly pension, however, has failed to release rupees 15,90,727 towards arrears of pension and gratuity. Full stop. The petitioner had filed a representation dated 20th May 2025 for the release of the arrears of pension and gratuity, however, no response is yet received. Full stop. Being aggrieved by the inaction of the respondent, petitioner has preferred the present writ petition. Learned counsel for the respondent seeks and is granted 4 weeks time to file affidavit in opposition. The reply to the same, if any, within 1 week thereafter. List.
10th November.
10th November.
Along with other matters, my lord. 16 matters.
Other matters are 19th.
9. না এটা না, তার আগের 16টা ম্যাটার একসাথে হয়েছিল। 16 matters, my lord, 10th November has been fixed. Same similar matter. This is also the similar matter.
Okay, we'll see. 19th
Yes.
November.
19.
Whatever will be the outcome will be followed in.
Yes, same outcome. Yes.
19th. Yes.
Lordship, item number 15, I am on behalf of the petitioner, Lordship.
Yes.
Lordship, I am filing the affidavit of service.
Who's for the respondent corporation? Municipality.
For answering respondent. Chabdani Municipality, Lordship. Service has been completed, Lordship.
Champadani, that Mr. Sinha had appeared today, huh? Champadani, no? That Mr. Sinha was appearing for Champadani. Who appears for Champadani?
Lordship, yesterday the matter was taken up by your Lordship.
Yesterday, obviously, nothing happened, you know it. Who appears for Champadani?
I'm for the statement.
You find out who appears for Champadani. It's very difficult to pass orders. Miss Tanushri, any idea who appears for Champadani?
Lordship, in that event, may I say one thing, Lordship, with the Lordship's permission? Lordship, kindly fix the matter on Friday, and in the meantime, I will serve one notice by intimating the next date to the Chabdani municipality. Though Lordship, affidavit of service has
I
been
know
completed.
affidavit, it will not help you. I can
So
pass an
Lordship,
order.
kindly
Also.
give me a direction.
Friday. Come back on
Kindly
Friday.
give me a direction. I will serve a notice, Lordship. Kindly pass an order, Lordship.
None appears for I'll pass an order only. You communicate the order to them. The petitioner has preferred the present writ petition.
May I say
Pension
the
matter. Pension.
gratuity, Lordship.
Gratuity.
And retirement benefit, Lordship. 7,30,000 is the amount, Lordship.
All right.
And
The petitioner has
municipality
preferred the
already
present
accepted.
petition.
Yes, this amount is payable.
Being aggrieved by the inaction of the respondent in not releasing his retirement dues, particularly his gratuity amount of rupees 7,30,000.
30,000, Lordship.
Despite lapse of more than 1 year from the date of his retirement. Full stop. The petitioner had joined the services of the municipality on 1/12/1985 and retired on 31/7/2024. Full stop. The pension payment order was issued on 18/7/2024, fixing his monthly pension at rupees 20,400 with effect from 1/8/2024 and determining his gratuity at rupees 7,30,000. Full stop. Although the petitioner has been receiving his monthly pension, the arrears of gratuity has not been released. Full stop. Being aggrieved, the petitioner had made a representation dated 21/11/2024 requesting disbursement of his gratuity.
And further on 2/12/2024.
Stop. In response,
further on 9/6/2025, Lordship.
In response, respond number 6, wide letter dated 2/12/2024 intimated that due to financial crisis, the gratuity could not be released and would be released subject to availability of fund. Full stop. The petitioner, having waited further, submitted another representation on 9/6/2025. Full stop. However, no response has been received till date. Full stop. In these circumstances, the petitioner has filed the present writ petition. Full stop. The affidavit of affidavit of service is taken on record. None appears on behalf of the respondent, Champadani municipality, despite service. Full stop. Let affidavit in opposition be filed by the respondent municipality within a period of 4 weeks. Reply to the same, if any, within 2 weeks thereafter. List after 8 weeks. Petitioner shall communicate the order passed by this court to the respondent municipality. और यहीं से भिजवा दो. Let a copy of this order be communicated to the respondent municipality. Chairman Champadani municipality.
Lordship, the returnable date is?
19th November.
19th November. I'm deeply obliged, Lordship. Deeply obliged.
Well, this is my writ petition, my lord. Well, the petitioner, my lord, the is a employee, retired employee of the Jiagonja Jingmon municipality, my lord. similar matter was moved before your lordship, my lord. And the earlier occasion, the petitioner also moved a writ petition before this court. Your lordship giving the direction to consider the case of the petitioner. They have rejected the pair of the petition on the sole ground that the prior permission has not been taken. But the facts remains that the prior permission was taken, and your lordship, considering their stand, my lord, delivered a judgment, my lord. I am handing over.
My lord,
before
your
your
lordship, kindly come to the one impugn order, my lord, passed by the local body. My lord, kindly come to page 37. Page 37.
Yes.
My lord, may I go through the said report, my lord, said decision from the very beginning.
Relevant portion, last two pair.
Portion, my lord, your lordship, come to third paragraph, my lord. 1, 2, 3, fourth paragraph. And whereas it appears from the available record that the petitioner was initially engaged as a casual employee on 7/8/1987 in terms of appointment letter by number ato issued by the chairman of the said municipality. Thereafter, he was absorbed to the lower post of lower division clerk on 2/3/2009 in terms of Board of Councillor resolutions without prior approval from the government. However, his appointment to the post of lower division clerk does not come under the purview of the memo number such and such UD and AMA department. Then, my lord, your lordship, kindly come to my lord paragraph, my lord, next, my lord, underline last paragraph, bottom paragraph. And whereas, by number the pre-secretary, Department of Urban Development and Municipal Affairs has reiterated that ULB should not engage should not engage any casual workers on monthly remuneration basis without prior written sanction of the state government. Let him show the written sanction of the state government. Well, without written sanction of the state government,
kindly see the page.
Let them file their reply.
Kindly see the page 25.
Sir, let them file their reply.
Opposition.
Let them file their
And my lord, this is the judgment your lordship passed.
I know.
We shall file the
This will also be done, but till the time the pleadings are not complete, I have to follow that. Let them file their reply, we'll pass an order.
That's what. That would
The petitioner has preferred the present writ petition, challenging the order dated 7/5/2025 passed by the director, local bodies, whereby his claim for grant of pension was rejected. Full stop. The petitioner has also sought a direction for release of his pension and other retirement dues. Full stop. This is the second round of litigation, earlier, this court, by order dated 24/3/2025 in WPA number 3292 of 2025, disposed of the writ petition by directing the director local bodies to take all necessary steps for expeditious processing and release of retirement dues of the petitioner within 4 weeks from the date of submission of all requisite document. Full stop. In compliance of the said direction, the director local bodies afforded an opportunity of hearing to the petitioner as well as the respondent municipality, and by way of the impugn order dated 7/5/2025, rejected the petitioner's claim for pension and retirement dues on the ground that his appointment to the post of lower division clerk was done without government approval. Learned counsel for the petitioner submits that the petitioner has rendered unblemished service of 37 years with the respondent municipality. He was a pre-1992 casual worker who was subsequently absorbed as a permanent employee by virtue of a resolution dated 17/2/2009 passed by the respondent municipality in compliance of the directions of the director local bodies issued on 22/12/2008. Full stop. It is therefore contended that the petitioner is entitled to pension and other retirement benefits. Full stop. Learned counsel for the respondent municipality seeks and is granted.
Well, the state,
respondent state seeks and is granted 4 weeks time to file Affidavit in opposition, reply to the same if any within 2 weeks thereafter, list after whatever date.
Well, matter to appear, my lord.
19th.
Affidavit of service.
Affidavit of service is kept on record.
My lord, I appeared for the petitioner.
Yes, sir.
This is affidavit of service. My lord, this is an appeal for change of surname of a minor child. The petitioner is the mother of the minor child who was married to one Subhasis Bhattacharya on 21st January 2014 and ultimately got a decree of divorce from an appropriate court. The page number 16, my lord, page number 16, dated 12th April 2023. And since then, the child is living with the mother.
Yes.
Before the marriage was decreed, both of them entered into a memorandum of settlement, wherein chapter 3, page number 21, my lord, the husband, Subhasis Bhattacharya, absorbed all his responsibility from the child and categorically stated that shall not cause any hindrance, 21 page number 3 column, hindrance thereto in any manner whatsoever.
Which para, sir? Which para? Page 21.
21, my lord.
Which paragraph?
Paragraph 3. Paragraph 3.
Yes.
Shall not cause any hindrance thereto in any manner whatsoever and shall not infringe upon the manner in which the child is and will be nurtured in future.
Yes.
It's a mutual agreement. Then on 15th 11/2023, the mother of the child contracted another marriage with one Dhananjay Das by certificate of marriage executed on 15th 11/2023. Dhananjay Das. Page number is 25, my lord, and it's just page number 25. And since then, the child is living with a mother with the stepfather, who has taken the child as his own child and taking all absolute care and attention for her upbringing.
Yes.
But in the birth certificate, the name is Srijoni Bhattacharya still there, which is adversely affecting his admission in the school and issuance of certificates, governmental certificates like Aadhaar card and or PAN card, etc., and other government documents, etc. So the Dhananjay Das made an application before the Kolkata Municipal Corporation with an appeal to replace the surname with the surname Das instead of Bhattacharya, and also to replace the name of the biological father with that of name of the stepfather. This is application page number 29 and 30, my lord, 29 and 30. In the said application, Mr. Dhananjay Das also enclosed and enclosed an order of this honorable court passed by a coordinated bench.
Yes.
In the case of Navadvip Municipality and another versus Orpita Chaudhary, WPA 88 of 2000.
Sir, where is the service to the father?
Yes, man.
Service to the father. Have you effected service on the father?
Yes.
On the service on the father.
Yes, my lord, I duly.
How have you served him? Because there's nobody.
I have served through speed post, and that I have also submitted the affidavit of service hearing.
Serve him again.
Again, sir?
Yes. Serve the father again.
By speed post, my lord?
I'll give you liberty to serve. Where does he stay? Where does he stay, the father?
He is living in Mogra, Hooghly, another district.
Within West Bengal.
Within West Bengal.
Speed post. Then, my lord, you post it after the vacation, my lord.
All right. Learned, the petitioner has preferred the present writ petition, seeking a direction upon the respondent municipality to effect the change of surname of the minor daughter of the petitioner number 1 from Bhattacharjee to Das, full stop. The said request was rejected by the Deputy Municipal Health Officer, vide order dated 6/5/2025, full stop. Petitioner number 1 is the biological mother of the minor girl, comma, Miss Srijoni Bhattacharjee, comma, whereas petition number 2 is her stepfather, full stop. It is the case of the petition number 1 that the minor was born out of the wedlock with respondent number 4, full stop. Subsequently, comma, the marriage between the petition number 1 and respondent number 4 was dissolved by a decree of divorce dated 12/4/2023, full stop. Thereafter, comma, the petition number 1 remarried petition number 2, comma, with whom the minor daughter is presently residing, full stop. It is further submitted that the respondent number 4 has had voluntarily given permanent custody of the minor child to petition number 1, comma, and had severed all his ties with the child, comma, and has no role in her upbringing, full stop. The minor has been residing with the petition number 1 and 2, who treats and nurtures her as his own daughter, full stop. In these circumstances, the petitioner sought to change the surname of the minor from Bhattacharjee, inverted comma mein kar dena, to Das, and accordingly submitted an application before the Deputy Municipal Health Officer on 17/2/2025, full stop. However, comma, by the impugn order dated 6/5/2025, the said request was rejected. Learned counsel for the petitioner submits that this court in WPA number 888 of 2024, wide order dated 29/2/2024, comma, has allowed an identical prayer for change of surname of a minor child in similar circumstances, full stop. Being aggrieved by the rejection of their application, the petitioner has been constrained to file the present writ petition. Learned counsel for the respondent seeks and is granted 4 weeks time to file affidavit in opposition, full stop. Reply to the same, if any, within 2 weeks thereafter. List after 6 weeks. Affidavit in opposition, none appears on behalf of the respondent number 4, full stop, despite service, full stop. Let this matter be listed after 8 weeks. You file your affidavit, we'll pass an order.
Lordship.
Similar order needs to be passed, madam. You know,
Lordship, coordinate benches orders are there, but let the father come up, your lordship, we will consider.
My lord has also passed a similar order very recently.
yes, I have also passed an order. She was there in that matter.
No,
You
that
were there.
In one matter, I was not there. Another matter, I was there.
There are other similar orders passed by other coordinated bench of the High Court.
Let their reply come on. Let their reply come on record, then we'll pass. Because they'll take the objection of section 12 and all that.
Section 15.
15.
Law doesn't permit.
My lord.
But there are coordinate bench observations which permits.
My
but
lord,
law doesn't permit.
while rejecting, they have cited only one reason. Please go and obtain a specific order from the High Court.
Because their hands are tied.
Yes.
Because of the awesome observations of the Honorable Apex Court also. That is the reason.
Please, Lordship. I am for, I am for the petitioner. Mr. Alok Ghosh appeared for the,
Yes.
This is my affidavit
Lordship,
service.
here, your lordship, the instruction is not yet received. We have received a very cryptic instruction.
No,
and
no,
let
no,
the
my lord,
matter
can't-
appear after vacation, your lordship.
No, my lord,
Because
I am
situations
Thapadi.
like this, we have sought for instruction. The
This
as
is
per
in
our
Calcutta.
record, your lordship, the land has not been acquired by the KMC. But what is
That-
the position, your lordship, whether the those hoardings are there, your lordship? So let the matter come
that-
up after vacation, your lordship, and
That,
come up with the
that
appropriate
Just a
instruction.
minute.
my lord, on Monday.
Just a minute.
Monday is
Yes.
holiday.
Monday is. Only you will come on Monday.
No, Monday they took time for 2 days in order to go instruction. My lord,
I
can't,
admit that we have.
that
said
is my
that
want
is
to
the-
say.
But some records are required to be scrutinized, your lordship.
No, my lord, kindly see the,
Land has not been acquired. That is the
my lord, that can be recorded, my lord, the land has not been recorded by the.
that is
court.
the record itself, the writ petition itself that has been annexed.
File your report, madam. File it.
Lordship.
Right on the petitioner has preferred the present writ petition. Seeking a direction against the respondent municipal corporation to release the land. Release the land of the petitioner situated at Moza, Farpur. What is it? Farpur. Farpur. Jail, jail number 6, RS Khaitan number 310 and 304. Khaitan number 310, Dag number, RS Dag number 234/580 under PS Rabindra Nagar, which has been alleged to be illegally encroached upon by the respondent corporation. It is a case of the petitioner that he is the co-owner of the premises in question by inheritance. Full stop. The petitioner, along with other co-owners, were in physical possession of the said property. Full stop. It is the submission of the petitioner that the said land is a Shali land and the same is lying vacant. Full stop. Hence, the petitioner and the co-sharers were putting a boundary wall on the said property. Full stop. However, the official of the respondent corporation prevented the construction of the boundary wall by saying that the said land has been acquired by the respondent corporation. Full stop. Later, the respondent corporation had put up a board on the said land stating that the land belongs to the Garden Reach Water Works under the Calcutta Municipal Corporation. Full stop. It is the submission of the petitioner that he and his siblings are the owners of the said piece of land and it had never been acquired by the by the GRWW under the Calcutta Municipal Corporation. Full stop. The petitioner had also filed an RTI application wherein by reply dated 7/7/2025, the Land Acquisition Department, West Bengal clarified that the said land under consideration has not been acquired. Full stop. Being aggrieved by the alleged illegal encroachment by the respondent corporation, the petitioner has preferred the presented petition. Learned counsel for the respondent corporation seeks and is granted 4 weeks time to file affidavit in opposition, reply to the same if any within 2 weeks thereafter, list after 6 weeks.
The state should also appear, your lordship, because if the land has been acquired, it is acquired by the state.
Who appears for the state here?
Nobody is appearing. The service is complete. State, I think that the state has service is not complete.
None appears for the state. The state is also directed to file an affidavit in opposition.
Lordship.
The state is also directed to file an affidavit in opposition within a period of 4 weeks, reply to the same if any within 2 weeks thereafter.
In the mean, some protection, my lord.
What protection?
Given because
My lord, they have no right. দাঁড়ান আমাকে বলতে দিন।
Nobody is taking anything, sir.
My lord, kindly consider
nobody is
they have not acquired this land by the corporation. That can be recorded, my lord. Only they are submitted. That will clear the
nothing.
My lord, they have stated just now.
Sir, I have recorded all your submission. They will file their affidavit.
What is there in the record? Nothing new.
Well, the corporation has no power. My lord,
Sir, I know whether the corporation has power or not. That's just why I have recorded everything. Nothing more needs to be done.
Supreme Court judgment, my lord, where the
Sir, am I deciding the matter today?
But they are creating problem, my lord.
So the problem will be solved. I'm just coming back. Sampadani.
Item 16.
16. Item 16, mark his appearance.
I beg to appeal for the petitioner, Madam. This is the affidavit of service. The petitioner before your lordship, Madam, is a developer who has been developing for almost 2 years now. We are at the verge of completion. Now, my lord, throughout all the records which are available to public viewing, my lord, the land is a land, not a pond or a tank. Their own record says so. Previously, it was a Thika land. There also, my lord, your lordship knows, my lord, if it is not a land, it cannot be a Thika land, my lord. That is the definition says so, my lord. Because to be a Thika tenant, I'll have to either own or possess a structure. A structure cannot come up on water. They have given a sanction plan 2 years back. Now, my lord, I don't know for what exigency, my lord, maybe because the ensuing pujas, they have suddenly come up with this theory that the plot of land is a tank. Whereas the list of tanks they maintain does not say that this particular address is a tank. Their internal report, signed by the same officer who has given the impugn notice, says their internal report says that it is not a tank. Now, my lord, suddenly on 19th of August, they have given me a stop work on 3 grounds. Well, I'll take your lordship through that, my lord. But before that, kindly take the documents once. Can you, my lord, first take page 35?
Yes.
My lord, if your lordship, well, if it is legible, my lord, I have another fresh copy also if required.
No, I can read.
Yes.
Tell me.
But kindly see the top part. Top after the name of the street, there's a heading called name of the street. Absolutely at the top. It's an assessment role, my lord.
Borough, ward number, street number.
Name of the street, yes. But absolutely at the top.
Yes.
Premises number, name of the street.
Yes.
Thereafter, kindly see heritage. Under heritage, it says.
Yes.
It says no.
Yes.
Then pond.
No.
It says no.
Yes.
Then, my lord, kindly take the next document, page 36. But this is also their part of their inspection book. Kindly take the top marking at this page, page 36. That change of type from Thika Pakka approved. There was a Pakka structure was existing on that plot of land, but these are all old documents I'm showing. Then kindly take page 37.
Yes.
Right hand side bottom, Muller. Your lordship will find under the name Ganapati Shur Sharoni, the address is mentioned. Thereafter, owner's land. Handwritten, Muller, on the right hand side,
Yes.
towards the bottom.
Yes.
Ganapati Shur Sharoni, owner's land. Then, Muller, kindly takes page 38. It is the same officer's pro forma report. For this was, Muller, the purpose of this document was to sanction my building plan. Kindly see on the right hand side under character second box. It is a land. Mother premises, that is 132. Mother premises was land and tank. But my premises is 132, the second one.
Oblique 1, oblique H, oblique.
Yes. But that has been later renumbered. Your lordship will find the actual address as serial number 5. 132 by A by 1 Ganapati Shur Sharoni. But the last entry at serial number 5. Maharaj has found that 132 A by 1 Ganapati Shur Sharoni. Kindly see the corresponding entry on the right. Area 6K, nature of use is land.
But yours should be the first one, right? Area 8K, nature of use.
132 by A by 1 Ganapati Shur Sharoni.
Yes.
That is where I am developing.
Yes.
The nature of use is land. Then kindly see serial number 6. As per aerial map, there is no water body.
Yes.
Then serial number 7. As per smart map, in the year 1913-14, a portion of western side of the aforesaid premises is tank, but at present, tank does not exist. Therefore, from the time they sanctioned the building plan, there was no tank in my premises. Then can I take the last line of that observation? No water body found during inspection within the above mentioned premises. And on this basis, a sanction plan was given to me. Then, my lord, kindly take page 40. This is the conversion from Thika to non-Thika land.
Yes.
Matlab, this is the position with regard to land. Matlab, the only other thing, matlab, I cannot prove the negative, but kindly take page 41. This is their PMU list, which says that ward-wise list, that in this ward, how many tank or pond is there. But in this list, this is their ward number 2. Kindly see at the top, ward number 2 in the box.
Yes.
But this entire list of ponds does not reflect my premises number. Now, this is the position and character of the land. Now, my lord kindly takes the impugned notice at page 74A. And my lord, just for context, the building permit and the sanction plan was given to me on 5th of August 2023. Now, my lord, after 2 years, they come up with this notice: illegal filling of water body at 132A Ganapati Sur Sharoni in ward number 2, Borough 1, in contravention of so and so. It has come to the notice of Kolkata Municipal Corporation that some development work has been undertaken by PR or his agent, including filling up of wetland tank at the aforesaid locality without obtaining permission from Kolkata Municipal Corporation and in contravention of the provisions of the West Bengal Town and Country Planning Act 1979 and the notification issued thereunder by the Kolkata Metropolitan Development Authority and the West Bengal Inland Fisheries Act amended. Under the provisions of the Act, character of the existing land should not be changed without obtaining permission from KMC. Under the circumstances, he or she is filling a tank or lowland at the above mentioned site, there is a chance of violation of legal parameters enforced by the state government and the local authorities, and hence have made himself herself liable to be prosecuted under the various provisions of the Inland Fisheries Act and the notification issued by the Kolkata Metropolitan Development Authority under the West Bengal Town and Country Planning Act 1979. Please, therefore, take notice under section 53 of the Town and Country Planning Act and section 17A of the 1993 Inland Fisheries Act that unless he or she takes action to restore the land to its condition before the said development work took place within a period of 30 days from the date of receipt thereof, proceeding in accordance with law will be taken against him or her without any further reference so and so. But I am seeking cancellation of this document. Now, my lord, your lordship has found, first of all, reference of the KMC Act, then the West Bengal Town and Country Planning section 53. But kindly take section 53 of the West Bengal Town and Country Planning Act.
Yes, sure. Yes.
Kindly take 53, my lord.
Yes.
Notice regarding unauthorized development or use otherwise than in conformity with the Land Use and Development Control Plan. Where any development or land has been or is being carried out as mentioned in section 52 of the planning authority or the development authority shall serve on the owner a notice, require him within a period of 1 month after the service of notice to take such steps as may be specified in the notice. So, what steps I'll have to take has to be mentioned in notice, and shall be what steps? A, in case specified in clause A, C, or E of subsection 1 of section 52 to restore the land to its original condition. In case specified in clause B of subsection 1 of section 52 to pay development charge. In cases specified in clauses D or F of subsection 1 of 52 to secure compliance of the conditions or with the permission as modified. Therefore, if any authority, which has to be first of all the development authority, that's I'll come to that in the second limb. If any authority gives me a notice under section 53, that authority must mention in that notice that what violation I have committed of section 52, whether it is A, B, C, D, or E, and accordingly my steps will follow, and they must mention what steps I will take. Kindly take note 52 once. 52.
Yes.
Penalty for unauthorized development or for use otherwise than in conformity with the Land Use and Development Control Plan. Any person who, whether at his own instance or at the instance of any person, commences, undertakes, or carries out development or changes use of any land or building. A, in contravention of any LUDCP. B,
without obtaining a certificate of development charge under clause A of section 45. C, without permission as required under this act. D, in contravention of any condition subject to which such permission has been granted. E, after the permission for development has been revoked under section 51 or in contravention of the permission which has been modified under section 51. None of this is mentioned in the notice, my lord. Blank, my lord, omnibus saying section 53. You change the character under section 53. So, my lord, this act will not apply because you have not mentioned what I need to do. Number one. Number two, the development authority under this act is the Kolkata Metropolitan Development Authority, not the KMC. KMC cannot, my lord, assume the jurisdiction which has been bestowed by this act upon the development authority. Maybe the mayor of KMC is part of the board of the development authority, but they cannot assume the powers and jurisdiction of another statutory body, being a statutory body. Now, my lord, next kindly take the Inland Fisheries Act, which is the other provision which has been mentioned. 17A.
Yes.
Chapter 3A, bar to conversion of water area, etc. for other use. No person put any water area, including embankment, measurement, 5 katas or so and so hectares or more, which is applicable for being used as fishery or any naturally or artificially depressed land holding measuring 5 kata or so and so or more, which restrains water for a minimum period of 6 months in a year to such use other than fishery may result in the abolition of fishery, or fill up any water area, including embankment or naturally or artificially depressed land holding as aforesaid with a view to contravention into solid land for the purpose of construction of any building thereon or for any other purpose, divide any water area including embankment or naturally or artificially depressed land holding as aforesaid into parts so as to make any such part measure less than 5 kata or so and so hectare for any purpose other than pisciculture or transfer of any land such area including embankment or naturally or artificially depressed land holdings as so divided to any other person. If the competent authority on receipt of information, they will move so and so and so forth. But these ABC is also not mentioned in the report, in the impugned order which has been given to notice which has been given to me, that how I have violated this when their own records throughout in the contemporaneous time, historically, nowhere the land is mentioned. Suddenly they invoke 17A after 2 years of construction, my lord. Therefore, your lordship will kindly set aside this notice, my lord. There are other intervening facts here, my lord, which are not required for this purpose. For today's purpose, my lord, let them say that all their reports and their, my lord, and your lordship, my lord, one thing, 74A, your lordship has noticed that it is signed by EEC Borough 1, Executive Engineer of Borough 1. Your lordship
So they
will
had
find.
issued this notice to you, then after that you have replied to it, right?
Yes, my lord, I have replied to it. That's the reply, my lord, is at page 75 onwards.
Page 75.
5 onwards.
And then any final order passed?
No, no, no.
To cut short, my lord, to cut short the matter, my lord, this officer actually given the power by the commissioner for actually restrain the illegal filling of the pond. Here, my lord, if your lordship kindly take page 38 once, the mother premises, if your lordship kindly see, that is land including tank. And thereafter, my lord, the assessment department, survey department, building department, civil department, the power was given to the civil department. Probably, my lord, I have a very bad case, but the thing remains, my lord, to scrutinize the whole thing regarding the issues is actually.
Your document themselves are saying there's no tank.
My lord, the building plan was given, but
Yes.
the different are 4 departments. What I am actually trying to impress your lordship, that scrutinize the whole thing, that record but report what I am saying or I am
Without granting a building permission to somebody, you
That-
don't scrutinize.
that was scrutinized. So what I am on, my lord, 4 department or 5 department are there. My lord, to cut short the matter, time bounding, my lord, municipal commissioner or authorized representative may be sent this to my lord, because every department has certain records. So, my lord, kindly send back the matter to the municipal commissioner or my lord authorized representative to consider the matter in a, my lord, time bound fashion.
They have already replied.
Because I
nothing
am
to
not
pass.
got actually the whole instruction. The whole difficulty is this. I am not getting the instruction. Very partial. That is the he issued the notice.
Like he's just being troubled. He's being harassed.
My lord.
It looks like he's being harassed. First, you give him the permission. and
Same
then
person.
Same person.
No, show the signature. My lord, extremely sorry, my lord. That is
All your documents are showing there's no tank. 1913-14.
My lord, this is not the same person, my lord. This
Yes,
is
yes, I'm showing. I'm just for my learned friend's satisfaction also. Page 39 kindly takes.
Yes.
Towards the middle center, your lordship will find a stamp of Executive Engineer Civil. 39 middle. It is actually absolutely in the middle of the page. The stamp. Executive Engineer Civil. Your lordship found that?
the next line, my lord, E and H department, that is Environment and Health
Then,
Department. That is
then
there
let
is
my
student-
learned friend also say that this person, Director General Environment and Heritage KMC, beyond that, after commissioner, if any other authority is there or not in KMC,
My
the
lord,
highest authority is giving this report.
My lord, the whole thing is this, my lord, the mother premises. your
Only when the
lordship-
puja comes, now they have
My-
suddenly discovered a pond in my
my lord,
land.
there is a specific complaint. There is a specific complaint who is residing just besides that premises. That is Gopinath Ganguly. He actually alleged that from his childhood he is seeing the pond. Whatever it may be, my lord,
What?
it may be a my lord mistake.
Childhood seen the pond. There's no pond in existence. From his childhood, he's seeing in his dreams.
My lord, that is not. That is the inspection is committed by the civil engineering department who is given the power
Sir,
for
when you are
actually,
giving them a
and thereafter, my lord, that is-
permission to construct, you have
that,
done
that,
your due
that was
diligence.
that was given, my lord.
So
There
how
are-
have you given that?
my lord,
After conducting a due diligence,
my lord, this
seeing whether the permission can be granted or not.
my lord, that was given. I am from my very
And then
beginning,
suddenly the pond comes in there.
my lord, that is
Your officer becomes smart by the day.
my lord, today, my lord, today, I have no instruction to actually say or submit more than that. What I'm on,
To
if
pass a reasoned order on his
Lordship,
reply. And in the meantime, don't do anything.
that should be stayed, my lord. I am also submitting that should be stayed. This notice is a very good case.
Very good case. You're just troubling people.
My lord.
Nothing else.
My lord, today I am not giving instruction, but
Take down. The petitioner has preferred the present writ petition, challenging the notice dated 19/8/2025, comma, issued by respondent number 6 under section 53 of the West Bengal Town and Country Planning and Development Act 1979 and section 17A of the West Bengal Inland Fisheries Act 1993. Full stop. By the said notice, comma, it has been alleged that certain development activities have taken place in respect of premises bearing number 132 oblique 1 oblique 1 H3
132A by 1
132A by 1
Ganapati
Ganapati Sur Sarani, comma, involving illegal filling up of a water body without obtaining prior permission from the respondent municipality. The impugned notice further directs the petitioner to restore the land to its original condition within a period of
it says 30 days.
within a period of 30 days. The case of the petitioner is that he has entered into a development agreement with the co-owners for the aforesaid land in the year 2019, full stop. Subsequently, comma, upon demise of one of the co-owners, comma, the petitioner executed a redevelopment agreement on 30th/6/2023, full stop. On the strength of the said agreements and power of attorney executed by the petitioner, comma, the petitioner had applied for sanction of a G+4 building on the said premises. Full stop. The building plan was duly sanctioned on 5/8/2023, comma, and the petitioner is currently carrying out the construction strictly in accordance with the sanctioned building plan. Full stop. Learned counsel for the petitioner, Mr. Bandopadhyay, submits that there was never any water body on the said land at any given point of time. Full stop. At any point of time, full stop. The land has always been recorded as land even in the official government records, full stop. In support thereof, the petitioner relies on Roman 1, the assessment, role and inspection book. Second, Roman 2, the performance report dated 24 to 2021, prepared in relation to the water body observation of the said premises. Roman 3, memo dated 16/11/2015, issued by the controller of water body, controller of TICA tenancy, controller of Calcutta TICA tenancy. And number 4, the list of water bodies in ward number 2, prepared by respondent number 1, comma, all of which demonstrate that no water body ever existed on the said land, full stop. Thus, the premises have always been recorded as land, and at no stage it has been shown to contain any water body or tank, full stop. Accordingly, the petitioner prays for setting aside the impugned notice dated 19/8/2025, full stop. These are the documents you have relied upon.
Yes, along with the pro forma report.
I have recorded that
Great.
pro forma report. It is further contended on behalf of the petitioner that he had filed a detailed reply to the notice on 9/9/2025, full stop. Learned counsel for the respondent submits that the said reply filed by the petitioner may be duly considered within a time-bound period, full stop. In view of the aforesaid submissions, comma, the present writ petition is disposed of with a direction to the respondent authority to consider the reply dated 9/9/2025 filed by the petitioner in response to the impugned notice dated 19/8/2025, after granting an opportunity of personal hearing to the petitioner, and pass a reasoned order within 8 weeks, within a period of 8 weeks from the date of communication of this order, full stop. It is further clarified that since this matter is being reconsidered by the respondent authorities, comma, no coercive action shall be taken against the petitioner pursuant to the impugned notice dated 19/8/2025 until a final decision is taken by the corporation, full stop. With the above direction, the present writ petition is disposed of.
Until a final decision and 2 weeks thereafter. So that if it is
Until
I can take or a fortnight thereafter.
Until the final decision, and the same shall not be acted upon for further 2 weeks to enable the petitioner to take appropriate remedies in accordance with law.
Disposed of.
Disposed.
Great.
What is the point of keeping it? Yes, Mr. Bhattacharya. What is this?
No. First, I invite your lordship, certain photographs.
My lord, Mr. Shonak Bhattacharya is appearing for the Asansol Municipal Corporation. He is on his legs before the division bench. Lordship, I'm praying for a passover.
Passover today, I have a special bench, and then I have another matter. He's here.
Now, please see page 28.
Yes.
29.
Yes.
30 and 31. Up to 32. We are in occupation. My great grandfather was allotted the tenancy. There is some eviction suit inter se, the predecessor in interest of the private respondent and my predecessor in interest. We are in occupation for the last 70 years. All on a sudden, without handing over any complaint and anything, my lord. At the instance of the private respondent, the surreptitious, my lord, method is being employed through the municipality, my lord, to
Evict.
my lord, alleging that these constructions are all, my lord, without plan, newly constructed. My lord, first of all, my lord, pages 28 to 32 on oath, my lord, these are the constructions which stand on the property. These are definitely not new construction which has come up, my lord, overnight. And my lord, on the basis of, my lord, we don't have, my lord, we have stepped as a tenant.
Yes.
Now, we have our godowns there. Suddenly, my lord, an attempt is being made to, my lord, get us evicted. In what way? By saying that please produce the plan. Naturally, my lord, we could not produce the plan. We don't have the plan. And, my lord, on the basis thereof, my lord, we have been given a 15 days, my lord, to get it vacated and demolished, raised to the ground. Alternatively, my lord, they are going to take steps. My lord, that is the sum and substance of the writ petition. My lord, I leave it to the, my lord.
Where is that order?
My lord, yes. My lord, first is, my lord, page 36 kindly comes.
9/9/2020.
Yes. Not on complaint, one complaint letter dated 20th May 2025. My lord, that is apparently not disclosed to any one of us. We don't know. And my lord, they heavily bank on, my lord, this during hearing.
Yes.
Not fourth paragraph,
Yes.
where asked to produce sanction plan. My lord, this building has not been constructed by us. How can we produce? First of all, my lord, this building is not a new construction which has come up, my lord, all on a sudden. This is apparently in existence for quite some time. My lord, this is a surreptitious way, my lord, if I may say so with respect, my lord, to get me evicted. And my lord, they are apparently, my lord, hand in gloves with the
Corporation.
my lord, this cannot be proved.
Yes. Yes.
Now, my lord, if your lordship would kind enough to come to page 37. The second paragraph, the sub-assistant engineer Asansol Municipal Corporation submitted his report from wherein it reveals that Ajay Makharia, Vijay Makharia and Akash Makharia have constructed masonry RCC structure with tin shed commercial measuring an area of 82.062 square meter equivalent to 882.987 square meter without obtaining any building sanction plan. Therefore, the construction is of RCC structure. Buildings, my lord, the photographs which has been, my lord, shown, my lord, in any way does not show, my lord, these structure. Whether these are the my lord, structures, my lord, it's doubtful. One. Number two, my lord,
So
kindly
you are
come.
disputing the pictures which have been put on record.
It will that I will take, my lord. That I will take, my lord. This has been copy has been directly handed over to me, my lord. Whatever instruction, my lord, I could gather from telephone, my lord. Kindly see, my lord, page 6.
Page 6
of the writ petition.
Yes.
Paragraph B. It is pertinent to mention that no copy of the said complaint was ever furnished to the petitioners, thereby denying them any opportunity to respond. Relying on such very unverified allegations, the private respondent requested a physical inspection, short demolition of the purported illegal construction, which the petitioners categorically deny. The petitioners had no knowledge of the said complaint or any proceedings initiated pursuant to until the receipt of the impugned order. The predecessors in interest have been tenants in continuous possession of the plot for over 60 years. Therefore, the admitted position is, my lord, they were tenants in 60 years. Now, my lord, this position has been, my lord, cleared by a previous judgment. My lord, tenant has no locus standi to challenge. My lord, I've brought those judgments and I will show from the statute itself. The
judgment which also says that the corporation along with the landlord should not evict the tenants.
Well, that point has also been decided here. They may have other right under the tenancy laws, but, my lord, they are not protected under the, my lord, Corporation Act. I'm my lord, brought that judgment. I can show it, my lord, regarding the maintainability of the writ petition. I can immediately satisfy regarding that factual aspect. Unless I show, my lord, documents from the corporation, I'm not able to say.
All right, file your reply. We'll see. Take down.
Well, lordship would kind enough to record, my lord, this submission, my lord.
Private
Because
respondent.
I'm ready to, my lord, satisfied today with your
Lord,
lordship
private-
regarding maintainability.
One thing, my lord,
Locus standi of the tenants.
I will just point out, my lord, with the leave of the court. My lord, the page number 6, my lord, my lord, kindly come, my lord.
You are appearing for the
I am
state.
for the private respondent.
Private.
I made the
Yes.
complaint. I am the owner of the house.
Yes.
The private respondent pleaded innocence. Page 6, point number B.
Yes.
It is pertinent to mention that no copy of the said complaint was ever furnished to the
That is
petitioner.
what he read out.
He thereby denying them any opportunity. My lord, if your lordship kindly see the order itself, I will not see the page number 36. Page number 36, because I have received the copy of the hearing notice. They also received. A hearing, my lord, third paragraph, I am reading from the third paragraph. Hearing notice were issued to all concerned parties, namely
Yes.
Saurabh Pasari. So Saurabh Pasari is the private respondent. Ajay Makeria is the respondent, the petitioner. Vijay Makeria and Sri Akash Makeria. By memo number dated 19th of June 2025, fixing the hearing on 23rd of June 2025. Accordingly, the complainant and the opposite party, namely Vijay Kumar Makeria and Akash Makeria, were present on the date of the hearing, but Ajay Makeria was absent in spite of the service of the notice of hearing. During the hearing, Saurabh Ajay Makeria, Sri Vijay Makeria and Sri Akash Makeria were asked to produce sanction plan in connection with their alleged construction at so and so premises. So, my lord, the complainant submitted the two registered deeds. However, why they have shown registered, I do not know. To determine the extent of illegal construction of the site inspection, measurement was imminent, and accordingly, notice of the same was issued to all the concerned person to remain. This is the background. My point is that they have first served with the notice of hearing. They attended the hearing. Second thing, that the measurement took place in their presence. They put on the note sheet. I have got the copy because being the complainant, I have received. Only ground they have pleaded their innocence, that we have not been served with the notice. But on that score, my lord, they are not entitled to
Is
any.
there any civil dispute pending between you and the tenant?
That is another aspect, my
Or
lord.
eviction?
That is eviction. As far they say that in 1998. So for the I do not have any record at this moment. From the annexer, I am saying that in 1998 one eviction suit was filed. Now they say they don't know about the latest position of the said eviction suit. The originally suit was filed according to them against their predecessor. Whatever it may be, I made a complaint that corporation has to see whether the illegal construction is existing on the plot or not. If it is not, then they are saved. If it is the entire thing is illegal, then it should be. Now they are taking a plea that I am hand in gloves. I am hand in gloves. That is unfortunate.
You have, at the time of giving them the tenancy, there was a structure in place. Who has constructed it? They have not constructed it.
Not
You are the landlord.
According to them, our predecessor filed a suit for eviction. What was the condition at that point of
What
time?
I'm
I do not
saying.
know. I do not know. Because what was the status of the structure? How much studied it was? Now the corporation upon inspection, my first point is that they cannot say they are innocent. They have been. I have got all documents. Kindly see. My lord, may I extend my copies? My lord, kindly see. First, my complaint was notice of hearing. Secondly, the attendance sheet. And kindly.
Sir, you file all this. We'll see
I will
that.
file, my lord. No interim order will be given to them because this
Interim
is not a
order-
case of innocence.
That we will see.
It is not a case of innocence. They are happily enjoying. Sometimes they have to remove. They are now taking the hand in gloves. What can I do? Instead of one-story building, if somebody puts it as a G+2 or like that and put their go down, they say that I am
Stay
carrying
down.
the
The
business.
petitioner has preferred the present writ petition. Challenging the memo number 1191 /PW /engineering /2025 dated 9/9/2025 issued by the respondent Asansol Municipal Corporation, directing demolition of the alleged and unauthorized masonry / RCC structure with tin shed measuring 82.062 square meters, situated near Gurudwara Bhavan, Ram Bandhu TALAW, Taloy, Asansol, PS Asansol, District Paschim, Bardhaman.
One more point.
Yes.
My lord, in the pleadings, my lord, I have been told what is the present condition of that suit. They are trying to take shelter of that. They could not spell it.
They
So
could
what is
not?
the outcome of the suit? Whether it is pending or it is already resolved. They are they,
Your
they are not.
suit, you have filed the eviction suit.
Sometimes back, if my predecessor,
So you will not know. Sometime back, your predecessor has filed.
I have no document. Long back. I have no
So
document.
whatever you have filed it, sir.
I have no document because my predecessor filed against their predecessor long
So
back.
whatever it is, you have to pursue it. If the predecessor has filed, he has died, then who will be the legal heir?
Yes, well, definitely.
You will be the legal heir.
Only thing is
So
that
you would be contesting it.
only
So
thing
you
is
should
that-
know it.
only thing is that I am not taking any advantage of that civil suit. They are trying to take advantage of civil suit. They have to say what is the condition.
Sir, we are not getting into the civil suit. Full stop. It is the case of the petition. Learned counsel for the petitioner, Mr. Bhattacharya, states that they have been the petitioner has been tenants in respect of the said premises for nearly more than 60 years. Full stop. A landlord-tenant dispute is pending between the petitioner and the private respondent, who is the recorded owner of the premises. Full stop. The respondent number 5 lodged a complaint dated 20th May 2025, claiming to the absolute owner of the property and alleging that the petitioner as tenants, were carrying out illegal and unauthorized construction over the said plot of land. Full stop. On the complaint, the petitioner on the said complaint, the respondent authorities initiated proceedings, pursuant to which a hearing was conducted on 20th of June 2025, followed by a site inspection dated 24/7/2025. Full stop. Thereafter, on 12/9/2025, the petitioner received the impugned demolition notice dated 9/9/2025. Full stop. Learned counsel for the petitioner states that they have been tenants in respect of the said premises for more than 6 decades, and the construction in existence was raised nearly 60 years ago. No new construction, full stop. No new construction has been undertaken at the site, full stop. It is urged that the impugned proceedings have been initiated at the instance of the private respondent number 5, nine, who have having failed to obtain an order of eviction against the petitioners, has sought to achieve indirectly what he could not have achieved through the due process of law. Full stop. It is further contended that the complaint dated 20th May 2025 was never supplied to the petitioner, thereby depriving them of an effective opportunity of defense in violation of principles of natural justice. Full stop. Learned counsel also pointed out that the impugned order has been passed by respondent number 6, whereas respondent number 6, whereas under law, the chief executive officer is vested with the authority to pass such orders. It has been passed by the executive engineer.
Superintending engineer, sir.
Full stop. It is the contention of the petitioner that learned counsel for the learned counsel for the respondent, Asansol Municipal Corporation, states that the present writ petition is not maintainable since the same is barred due to the fact that the petitioner is a tenant and the impugned order can only be challenged by either the owner or the occupier.
Or a person responsible.
Owner or the person responsible for carrying out the unauthorized construction. Full stop. Which judgment you rely upon?
266.
I know.
I'm ready.
Sorry.
You want to rely on something?
No. He was relying upon. I'm ready to reply to that.
All right. The said fact is, anything else which you want to say?
Lord, this is primary, my lord, regarding my landed friend has also taken a point regarding jurisdiction. That my lord has already settled jurisdiction delegation power is there. Therefore, that my lord's judgment will suffice, I think.
Yes.
Because Asansol, there are a lot of cases. In every matter is there. Learned counsel for the private respondent states that there is no impunity in the demolition order passed by the respondent corporation since there was no valid sanction plan and the entire construction has been carried out illegally. Full stop. The very said stand makes it abundantly clear to this court that the private respondent is taking the shield of the respondent municipality in getting the petitioner getting the petitioner ejected from the property without following the due process of law, since the civil dispute is already pending before the subordinate courts. Full stop. Full stop. The respondent, Asansol Municipal Corporation, seeks and is granted 4 weeks time to file affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. Learned counsel for the private respondent also seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. In the meantime, the respondents are directed not to take any coercive steps against the petitioner in respect of the premises in question, pursuant to the impugned demolition order dated 9/9/2025 for a period of 8 weeks or until further order, whichever is earlier.
My lord is fixing it on.
Then give it 12 weeks. For a period of 12 weeks, fix it after.
As you.
Grateful. Grateful.
Yes.
Well, this is appearing at my instance, my lordship was pleased to grant me leave.
Yes.
Very short point, my lord. Adjacent landowner of my property, my lord, now they are making a construction, my lord, a one-story construction, my lord, that has been enumerated in paragraph 5 and 6 of my writ petition, my lord. And there's on the western side of the property, my lord, there's a 14 feet wide government road. It's a public road. It's a thoroughfare. What they are doing is they are partially, my lord, taking a portion of the road has been encroached and constructions have been made, my lord. I'm only seeking a very limited direction, my lord. We had written, my lord, lordship will kindly take page 20 of my writ petition, my lord. 20, thereafter 23, 26, 29, and 32, my lord.
Yes.
All are representations made on 19th of September, my lord.
Yes. Who's appearing for the Asan?
My lord, we have served, my lord.
Asansol.
Asansol, my lord.
Why didn't you tell?
My lord,
Saurabh was here. Oh.
they have received, my lord, service on 23rd, my lord.
Rajul, you should have. He was right here.
I also asked him.
Can you?
Probably they have received, my lord.
He is the only person who appears for Asansol.
May I hand over the affidavit of service, lord? She will have a look.
Right here, he's here. Yes.
I should be candid, my lord. I told Mr. Bhattacharya, he said that he has not received any instructions, my lord.
That's
No
all.
copies, no instructions, my lord. I am only seeking a limited prayer, my lord, limited relief, my lord.
Beside his representation.
Decide a representation, hearing to be granted before the authorities, my lord. Whatever may be the case, if I succeed, I succeed. If I fail, I fail. As simple as that.
This was so urgent.
This was so urgent. This was so urgent. It was. Because and they are making construction, my lord, and municipality admittedly has not given any sanction to that construction, my lord, the adjacent land, my lord.
Take down the petition.
Let that inspection also be done by the municipality. Lord,
Whatever they have to do, they'll.
Yes, my lord. Grateful.
The petition, the present petition is agreed by the inaction of the
respondent
they-
in not taking any action in stopping the alleged illegal and unauthorized construction taking place at LR plot number 1377/3275 appertaining to LR plot Ketan number 5478 and 5477
Yes, ma'am.
lying in Moja Jamuria, comprised in jail number 21, ward number 2, Asansol Municipal Corporation. Full stop. It is the case of the petitioner. Learned senior counsel for the petitioner, Mr. Rijul Ghoshal, states that the petitioner is the neighboring land. He's a neighbor.
Adjacent land.
He's the neighboring landowner and has noticed alleged illegal and unauthorized construction being carried out at the above mentioned premises. Full stop. He has submitted a representation dated 19/9/2025, however, no action has been taken. Full stop. Learned counsel for the respondent, Asansol Municipal Corporation. Should I record?
At least I have not got anything. Milord.
what
I
I-
do not know whether
What I'll do is
Services
I'll-
23rd.
Mr. Saurabh Bhattacharya, who generally appears for the Asansol Municipal Corporation, is present in the court. He has been asked to appear in the present writ petition. Full stop. His engagement be regularized. Full stop.
Appointment may be regular.
His appointment may be regularized. Full stop. The present writ petition is disposed of with the direction that the respondent municipality shall consider the petitioner's representation dated 19/9/2025 within a period of
6 weeks.
6 weeks.
in a period of 6 weeks from the date of communication of this order, strictly in accordance with law, after affording an opportunity of personal hearing to the petitioner as well as the
Private
private
respondent,
respondent
yes.
or any other stakeholder, by way of a speaking order. Full
Grateful,
stop.
my lord.
With the above direction, the present writ petition is disposed of. Affidavits have not been exchanged.
The allegations deemed to be not admitted.
That goes
There
without-
is no allegation against him at all, my lord. I was just
So we
bringing.
could dispose it off because you are
Grateful,
here.
my lord. Grateful, my lord. Obliged, my lord. I won't be appearing before this side of the vacation, so I'm wishing your lordship, my lord, a fantastic Dasera vacation, my lord.
Thank you, you too.
Grateful, my lord.
And you have got all juniors from the criminal side.
No, my lord, Mr. Chakravorty assists me in most of the matters, my lord. Rest, my lord. Grateful, my lord.
My lord, in this matter, I am appearing on behalf of the private respondent, but no copy of the writ petition has been served upon.
Yes, Lordship. Your Lordship, I am praying for the petition.
Yes.
Your Lordship, the case is the Lordship. Petitioner number 1 is the widow lady and petitioner number 2 is the daughter of the
Petitioner number 1 is the widow lady
Ramindranath
and petitioner
Mukherjee.
number 2 is the
The
daughter.
daughter of the Ramindranath Mukherjee. The husband of the petitioner died in 2021, Your Lordship.
Yes.
And before that, Your Lordship, on the basis of 1999, a partition deed was executed between the co-owners of the Ramindranath, and thereafter the municipal corporation has mutated and BLRO authority has mutated the premises number 4G of the Vaishnav Ghata lane, Your Lordship. Your Lordship, on the basis of taking of advantage, Your Lordship, the private respondent making the construction about the petitioner land, Your Lordship. And surprisingly, kindly see the page number, Your Lordship. Page number
No copy of the
190.
petition has been
Your
served upon the
190.
private
They are
respondent.
regularly making construction, Your Lordship. Page number 119, Your Lordship, showing that they have obtained a sanction plan from the KMC on the basis of premises number 1 Vaishnav Ghata lane. But Your Lordship, the 1 Vaishnav Ghata lane, but the construction is making over the 4 Vaishnav Ghata lane, Your Lordship, the land of the petitioner, Your Lordship. This is the case, Your Lordship. I am praying for
at least protection, your lordship, further construction over the land, your lordship, till disposal of the, your lordship. They regularly they are making construction over the land, your lordship. This is the case, your lordship. Your lordship,
We can inspect the
KMC,
premises because 4G we have not inspected, and we can inspect and submit a report whether at all any unauthorized construction is going on.
your lordship, page number 73 is the KMC mutation 4G Vaishnav Ghata lane. And
To decide their representation. Let them decide your representation. They'll
Lordship,
finish
we
it
can
off.
do that also.
your lordship, till date, your lordship,
Building can
private
decide the
respondent are making construction over the land of the petitioner, your lordship.
See, the land dispute I'm not getting into.
No, your lordship, but the KMC issue the
Show me from the document.
Page number 73, your lordship.
Page number 73. What is page number 73? Yes.
Address premises number 4 Vaishnav Ghata lane.
Yes.
And owner is Sri Ramindranath Mukherjee.
All right.
The husband of the petitioner number 1 and father of the petitioner number 2, your lordship.
Yes.
Is the owner of the land.
Yes.
And BLRO mutation, your lordship, from page number 60. Your lordship.
These are all adjacent land. Maybe your father has given the land. How do we know whether it has been sold, not sold? Where's the sanction plan?
Yes, sanction. No. Your lordship, the vacant land, your lordship. Is a vacant land. I am deciding the Howrah, and it is a vacant land 4G vacant land, your lordship. The
Yes.
private respondent making construction over the 4G, your lordship.
Let them sing instruction then. I can't stop it.
Your lordship.
What is the document to show that they are raising the construction?
Yes, lordship. Page number. Yes, lordship. Photos. 119 of 119, your lordship, photos. And I have specifically lodged a complaint to the local police station and corporation. No action has been taken by the state respondent, your lordship.
This photograph is one Vaishnav Ghata lane.
This is a different
Yes,
photograph.
your lordship, one Vaishnav Ghata, but the
Disputed question of fact, how can this court go into it? How do you prove that the construction is taking place on your land?
one Vaishnav, they have obtained a sanction plan, one Vaishnav Ghata, but the construction is making over the 4G, your lordship.
So that can only be ascertained by the corporation.
Yes, your lordship.
So either I remind you back to decide your whatever representation you have made, or let them file the report.
Yes, lordship, file the till them, your lordship, I am getting.
Till then, I'm doing nothing. You have not even served the private respondent.
Your lordship, we have lordship.
They are here, appearing here.
Okay, I am giving copy.
And the note presentation has been given to the executive engineer. It seems the officer in charge, police.
No. Executive engineer, assistant engineer.
Is the copy.
Yes.
123 is the officer in charge.
87 page. Deputy engineering and assistant 87 page.
Page 87.
Yes.
There is no post of deputy chief engineer.
They have received, your lordship, and assistant engineering and commissioner.
We'll keep it on Friday. Come back with the instruction. We can dispose it off.
Inspection is to be done. We can do it. In the meantime,
At least come with the instruction.
with the instruction.
Not today, Friday. You also come back. We are giving you a copy.
Get Flora.
Lordship, if there's a one-liner order regarding inspection, your lordship, that would be expedite the process, your lordship.
Just give it. एक मिनट याद है ना?
Regarding 4G, Vaishnav Ghata byline.
The petitioner. The petition, the present writ petition is being aggrieved by the inaction of the respondent in not taking any action against the alleged illegal and unauthorized construction carried out at premises number 4G
Vaishnav Bhatta.
Vaishnanga Bhatta by lane, Police Station Netaji Nagar, Calcutta, at the instance of private respondents. Full stop. It is the case of the petitioner number one. It is the case of the petitioner that he is the owner. Petition number one, right?
Yes, petitioner
Peti-
number one.
It is the case of the petitioners that the petition number one is the owner of the aforementioned premises. Full stop. Due to her old age illness, comma, she is staying with petition number two at her residence at Bali, Havra. Full stop. However, in the meantime, the private respondent encroached upon the petitioner's land and are carrying out the illegal and unauthorized construction. Full stop. It came to the knowledge of the petitioner that the private respondents obtained building sanction plan for premises number one, that BR Vaishangata by lane, and but are carrying out construction at premises number 4 by 4G Vaishangata by lane. Full stop. The petitioner states that the said construction is being illegally carried out on his plot of land, though the sanction plan is for 1 Vaishangata lane and not for 4G Vaishangata lane. Full stop. Learned counsel for the petitioner further submits that he has made a representation dated 15/9/2025 before the, what is the date of that representation? Page 70.
Page 87, Your Lordship. 15 September.
15 September 2025. The same has not been acted upon. Full stop. In view of the said submission, learned counsel for the respondent corporation seeks and is granted time to take instruction. Let this matter be listed on Friday. You come back on Friday, we'll see.
Lordship, I'll try my level best.
If that is the case, then
So kindly direct them to
I'm copy.
give a copy.
We have filed it with a leave, my lord. It's some urgency.
After lunch? After lunch, I have a special bench. Then there is one more matter I have specially fixed at 2 p.m. After that, I'll take it, if there's any time left.
So I don't know, 23 mother I apply for the petitioner mother.
Yeah.
Like, there is some urgency in the matter, so I was just.
23, you want a date?
My lord, if your lordship could be, if it could be taken up, my lord. Or my lord, tomorrow, my lord.
Tomorrow it can't.
My lord,
Tomorrow is urgent side.
it's being added, I'll take only
Very
5
short,
minutes,
because
but,
my lord, very
I did
short
about
matter. my lord.
24.
My second half,
24,
every
I
matter
think
is short.
My lord,
Take them Friday, Your Lordship, because if my Lord takes
No,
the
my lord, there
second
is
half,
urgency. I'll tell you, lordship, I have.
so I have got difficulty, Your Lordship.
Second half.
My lord, I have some urgency in the matter. I have some urgency. I have some urgency.
23 my lord, then Friday at the top, my lord.
No, not possible.
that my learned friend had completed. I have to make submissions.
Just remind your lordship.
Sure.
Refresh just for 2 minutes.
Yes.
I'll refresh your lordship. He's completed. He said you have to do it before vacation. It's such an important matter. Let me, my lord, assist your lordship. I promise you that I will not take more than 10 minutes.
Not more than 10 minutes.
Not more than 10 minutes.
No, that refreshing part, let him do it then.
Yes.
I leave it to him.
Yes. My lord, simple, my lord, facts. Number one, I said I am a Thika tenant. Under, my lord, a strange concept, my lord, prevalent only in West Bengal. Bihar, Jharkhand, West Bengal.
Yes.
And now I'm told it's semi-defunct, but whatever, my lord, I could not prove that I am a Thika tenant. My lord, please have a look at the judgment. I am just going to show your lordship the conclusion. Judgment starts at 114. And, my lord,
Yes.
the conclusion is at 125, paragraph 46.
Judgment starts from 114 and
114. And, my lord,
yes, the
because
conclusion.
it went to Supreme Court, I don't even want to show, my lord, the rest. And
Yes.
paragraph 46, my lord, the findings and then the conclusion. is, my lord,
144.
126 at page 144.
Yes.
My lord, paragraph 126, subparagraph 1, the High Court view in Lokhimoni Dasi, which is, my lord, a celebrated judgment discussing the act, that's accepted. A, B, C, D, pakka structure, kacha structure, it's Thika, nothing else. Long and short of it is, my lord, if it was a Thika property, state would have become the owner of the property, my learned friend's clients would have gone. So, my lord, we fail over there. There's no difficulty. Now comes the question, what happens next? My learned friends, my lord, apply before the Supreme Court for possession. And, my lord, there is an order passed. My lord, please see, my lord, the affidavit in opposition. My lord, two documents from my opposition I will, my lord, refer to. This is the first document. I've given, my lord, yesterday I was supposed to give them, but because of the rains, my lord, we were not able to do it. Today, my lord, I have given them.
Today what time?
Right now.
Right. No problem. No problem. We are
I am not.
Accept. Yesterday it was
Two
raining.
documents.
Yes.
Yes. Two documents I want to rely upon. One, my lord. My lord, please have a look at page 56. Now, this application was moved and it's not entertained and it's been not held. Applicant is otherwise free to take recourse in appropriate remedy in accordance with law. Prayers, my lord, are at page 54. This is not MA 2107. Prayers are at page 54, directing the appellants to forthwith hand over vacant and peaceful possession. This was, my lord, beyond the scope, and in any case, Supreme Court did not entertain it. Supreme Court said that you approach, not you take recourse to appropriate remedy in accordance with law. Then, my lord, comes two suits. One suit by me, saying that I have become an owner by adverse possession because I've been there for many years, and his suit for eviction of my client, my lord, from the suit premises. Both suits are pending. There is, my lord, I am not admitting his title to ownership. I'm saying I am the owner of the property. If my suit fails, his suit will succeed and he will become, my lord, have my eviction. This being the situation, there is a dispute qua title to the property. Now, my lord, mutation. My lord, please have a look at section 183 of the Act.
The mutation doesn't grant any title or anything.
Absolutely. Absolutely. The question is whether he is entitled to it and what is the view expressed by this honorable court and the Supreme Court in a situation where there is a title dispute pending determination by a civil court. Section 183. Whenever the title of any person to any land or building is transferred, such person, if primarily liable for the payment of property tax on such land or building, and the person to whom the title is so transferred shall within 3 months after execution of the instrument of transfer or after its registration, if it is registered, or after the transfer is effected, if no instrument, will give notice in writing to the municipal commissioner. And Lord, please see subsection 3. The notice shall be in such form as may be prescribed, and if so required, will be bound to the purchaser will produce. So this is important. Notice in this form must be given. And then it's to be done unless, my lord, there's an objection, municipality to decide. Now, my lord, the form is appended to the rules. To the rules or on the website? On the website, not to the rules. I'm sorry, my lord. My lord, please have a look at page 70 of the affidavit. This is form number A42. So this is what you have to fill up for the purpose of having your name mutated. Upon transfer in your favor, you have to inform the corporation and you have to fill this up. You will get your name mutated. If there is no objection or any dispute, corporation will decide. Now, in this case, my lord, he's not even filled this up. He comes to your lordship with a case. I don't want to go to the corporation because the private respondent is politically connected. He hasn't even filled this up. Now, my lord, just 3 judgments, 3 paragraphs. Number 1, there is a genuine dispute as to time.
You have applied for mutation.
We have applied for restoration of our name. This form A42 I had filed originally when my name was mutated. This form is in the records of the municipality. And this is not the stand of the municipality that due to lack of filing of form, I can't.
This is the first prerequisite,
Yes.
which is absent in
Which
his
is
writ
complied.
petition. It is absent in his writ petition. He has not produced what form he is filled. Now, my lord, please have a look at one judgment of this honorable court. My lord, I do believe, my lord, this is 2017 SCC Online Cal 15709. Short kore. My lord, when there is a civil dispute, corporation is no one to decide it. So, my lord, it lies till the time the civil dispute is decided. My lord, settle law. Number 1, I mean, I'll give you a copy. One more copy. Huh? It doesn't matter. This is, it doesn't matter. Mark করেছে. I have my copy mark. Absolutely.
Yes.
My lord, this is, my lord, a judgment of a learned single judge, my lord. Please see paragraph, my lord, 1. Challenges an order of the Kolkata Municipal Corporation directing that the petitioner's application for mutation to be processed for joint mutation of the names of the petitioner. Now, my lord, if your lordship omits, my lord, the contentions and comes to, my lord, paragraph 24, this is, my lord, submission of one of the parties. Contention is, my lord, similar. Mr. Such and such submitted, I'm reading, my lord, paragraph 24, that it is evident from the sale deeds that the respondent number 1 is the absolute owner of the demarcated portion, is in possession by not challenging sale deeds, writ petition, admitted ownership, etc. Dispute with regard to title and possession remains unresolved till date. Both petitioner and the respondent number 9 have registered sale deeds in their favor. Last sentence of the paragraph in support of the proposition that the writ court cannot decide disputed questions of title, 2 judgments relied upon. Then, my lord, please see paragraph 26. Mr. Such and such then submitted petitioner's prayer for mandamus directing KMC to grant mutation in his favor in support of the property in question cannot be allowed. An act which an authority is duty bound to perform under the statute is to be done in terms of the statute, and the court cannot perform the act of the statutory authority by usurping the powers envisaged under the statute. He relied upon a decision of the apex court. So, my lord, mutation is to be done by the corporation. This matter can't be decided by court. Your lordships will direct, my lord, them to consider, if at all it's to be considered. If there is a dispute, nothing is to be considered now. Now, my lord, please see the finding. Paragraph 39. There's a prima facie, my lord, finding at the end of paragraph 39 that one party's sale deeds will prevail over the other. Then paragraph 40. There is clearly a title dispute in this case. The respondent number 1 claims to be in possession of some portion of 2 Chobaga Road as owner. Hence, KMC authorities have expressed their inability to mutate premises number 2 Chobaga Road in the sole name of the petitioner. I appreciate such difficulty of the KMC authorities, and I am in agreement with the submission of Mr. Kormokar that unless such title dispute is resolved by a court of competent jurisdiction, mutation in respect of premises number 2 cannot be granted in the sole name of the petitioner. In Municipal Corporation Aurangabad versus State of Madras, a 3-judge bench of the apex court, paragraph 13 and 14 of the reported judgment observed as follows. Paragraph 13, it is settled that mutation does not confer any right and title in favor of any one or the other, nor cancellation of mutation extinguishes right and title of the rightful owner. Normally, mutation is recorded on the basis of possession of the land for the purpose of collecting revenue. I'm going to cite this judgment also. I am in possession. He's filed an eviction suit against me, admitting my possession. In the present case, we find a disputed question of fact was raised by the parties with regard to title over the land in question. The appellant corporation, on the one hand, based such and such, I won't read it out. Court will not decide this. Then, my lord, paragraph 43. The apex court held in the state of UP versus Rajaram Jaiswal. KMC is the statutory authority which has been vested with the power of granting mutation, and court should not ordinarily usurp such power and pass a mandatory order directing KMC to grant mutation unless the court feels that there is absolutely no reason or justification for the KMC to refuse mutation. In my opinion, in the present case, refusal of KMC to grant mutation in respect of premises number such and such, sole name cannot be said to be wholly unjustified, etc., etc. Now, my lord, just 2 more judgments, my lord, and then I'll just sum up the law and stop. First, my lord, is 2021 SCC Online Supreme Court 802. This is the judgment, my lord, which is considered in many matters. Now, paragraph 6, my lord, it's a dispute with respect to municipal entry in the revenue records. My lord, last 3 lines, as per settled, last 5 lines, as per settled proposition of law, if there is any dispute with respect to the title, and more particularly when the mutation entry is sought to be made on the basis of the will, party who is claiming right title on the basis of the will has to approach appropriate civil court, get his rights crystallized, and only thereafter on the basis of the decision before civil court, necessary mutation can be done. Right from 1997, law is very clear. In case of Balwant Singh, this court had an occasion to consider effect of mutation, observed and held mutation. Had an occasion to neither creates mutation of property in revenue records, neither creates nor extinguishes title to the property, nor has it presumptive value on title. Such entries are relevant only for the purpose of collecting land revenue. Similar view is expressed in series of decisions thereafter, if not fiscal purpose, etc. And below, just one more judgment referred to, two more judgments below. 2015, volume 16, SCC 689. Lord, if I read out paragraph 13, it will be a rhetoric. It says the same thing. But I will just refer to paragraph 14. The disputed question of fact was raised by the parties with regard to title over the land in question. And Supreme Court said, sorry, under 220, Article 226, not to be done. And last, my lord, this is, my lord, the judgment relied upon by the learned single judge of this honorable court. Now, my lord, the last judgment is 2009. No, actually, I don't want to cite this because this is on revenue records. Revenue records and mutation are not the same thing, my lord. Let me not, my lord, cite that. My lord, may I just sum up? Number one, it's an attractive argument, and especially when Mr. Kaur, my lord, puts it in his, my lord, unimitable style. Inimitable style. But the fact of the matter is, what was decided up to Supreme Court was Thika, which has no relevance, qua possession, qua title, and has no bearing whatsoever. So, my lord, impressions ought to be given by saying that I have won up to Supreme Court. Now I have a right to have my name mutated. Is not correct. Number two. So, my lord, those judgments, my lord, do not assist him in any way. Number two, a learned single judge of this honorable court, and I have shown the judgment based on, my lord, Supreme Court judgments has said, it's, my lord, so I'm sorry, Supreme Court has said, who's in possession is the normal person to pay land revenue. And, my lord, I am...
Mr. Chaudhary, if it is not a Thika land,
yes,
then there is somebody who's the owner, right?
I'm the owner. By adverse possession.
But initially what you were claiming that's a Thika land.
No. Yes, I'm claiming that's, my lord, it's not a, I'm grateful, my lord, for the question. It's not, my lord, a concept. When I say it's Thika tenant, it does not, my lord, destroy my right to claim adverse possession.
The moment you're saying it's a Thika land, then the owner is basically
the right of a Thika tenant under, I don't want to go into that line of argument, but it's a fine question, my lord, which I thought of. My lord, if I claim to be a Thika tenant, does it militate against my right to later claim as owner under adverse possession? Answer is no, it doesn't. Because rights of a Thika tenant, loosely said, my lord, are largely like rights of owner. He can transfer it also. So, my lord, only thing which is achieved by, my lord, making the property a Thika property is, my lord, the claim of the so-called landlord, who's a recent purchaser, he's a developer. It's not that this is a man suffering for 50 years. I've been in possession for a long time. He is a recent purchaser. He wants to develop the property, get rid of me, which is why to corner me, he is doing all this. But regardless of that fact, the fact that I claim that he's a Thika tenant does not militate against my concept of, my lord, claiming adverse possession ownership. And suit is pending. He's participating in that suit. His suit for my eviction is pending. My lord, if Supreme Court judgment in Thika matter was to be construed in the manner in which he construed it, then Supreme Court would have given him possession. But Supreme Court did not give him possession.
No, but then the issue was entirely different. Supreme Court was only looking into the aspect whether the land is Thika land or not.
Yes, I am grateful.
I
am grateful. That's my submission. So with that judgment,
So with that, they could have never granted any right to them as far as the declaration of title or anything else is concerned.
That's exactly what I say. So if he doesn't have that, I'll be non-suited today if your lordship in my suit for my lord declaration of title because of my adverse possession. I will be non-suited if your lordship finds over here that I am the owner.
This is only the mutation.
Mutation.
This
So
has got
will-
nothing to do with your ownership.
So two propositions of law. Number one, whoever is in possession, mutation is his name.
Initially, the person who was there, his name has been struck off. Your name has been included in there.
No. Let's see the writ petition, my lord. Please have a look at the writ petition. Please see what records have been relied upon. What is the case made out? And what are the documents shown?
Reinstate. Roman 2, page 17.
Yes, my lord, I'm looking at, my lord. The first part of the writ petition is Thika tenancy. Then, my lord, please come to paragraph 11. Paragraph 10. On the strength of the declaration of Thika tenancy by order dated such and such passed by the Thika controller, the Kumars illegally and unilaterally applied to the Kolkata Municipal Corporation for recording the property as a Thika property and also for deletion of the name of the writ petitioner from the records of the Kolkata Municipal Corporation and consequent incorporation of the name, etc., etc. Now, my lord, please see this is just a certificate which is, my lord, shown as Annexure P5. Entire exercise, this is, my lord, when? My lord, this is 2025. My lord, Kumar's applied by order of 2010. So, my lord, for 10 he is allegedly now complaining. Now, my lord, please see paragraph 11. Then he makes a representation on 19 June 23. Then change of description according to him. Then Supreme Court ends in 2023 and, my lord, he's thereafter been writing. Now, my lord, after paragraph 24, your lordship will find why he's coming before your lordship. Petitioners reasonably apprehend inaction and apathy demonstrated by the respondent authorities was to cast a dark cloud in favor of one of the mayor in council political heavyweight, which is why he has to come before your lordship. Now, I ask myself three questions. Number one, this change, what is the reason for the change? What was the exact change? And after, my lord, the Thika judgment goes, firstly, what is the reason for the change? And why was, my lord, our names recorded 10 years ago? And what is the exact reason for rejecting or not considering or not acting upon his representation? Your lordship will see this. It has to be decided by the corporation. Just one sentence that yes, he's not a political heavyweight cannot be reason for the entire machinery under the statute to be bypassed. What is my submission? I am saying title can't give him possession because there is a dispute as to title. Number two, I am saying I am in possession. And I have been in possession for a long time. Maybe that is the reason my name has been included. So these are matters which corporation has to decide, and corporation has to go by title and by possession and cannot go by title because title is pending determination in two suits. So these are my submissions. This is, and in that judgment of Justice Banerjee, it's been held this is a statutory function by a statutory authority. They have to perform that function only in an exceptional case. If your lordship finds that no, either he is not in a position to perform or for some reason he is not performing in a very gross, my lord, egregious, my lord, incorrect way, then your lordship, of course, always has the right to step in. My lord, so this is matter A, because of my possession, should end here. And B, if there has to be a determination about the, my lord, change, etc., it has to go back before the corporation decision. Then, my lord, there is a remedy of appeal. It will come back ultimately. So, my lord, when the first argument was made, it is on the basis of my title. I want mutation. Now, when it becomes clear that on title you can't get on your alleged title you can't get, now it shifts back to there has been an incorrect change 15 years ago. So I want my name to go back in. And please also, my lord, take note of the fact that he moved without notice to me. It is only upon your lordship's intervention that, my lord, I am here.
And his name was struck off because I was recorded as a Tika tenant under the state.
Look, these are matters to be, my learned friend is right, but these are matters to be decided by the corporation. But this is just an order. Another division bench order which will not say the same thing.
No interference in mutation.
It's relevant, show it.
Minute, I read this, but I thought, my lord, it's more like an order. Mr. Ghosh is insisting. We have heard the learned counsel for the parties as the question of title is not decided in mutation cases. Ultimately, decision of civil suit has to prevail in no case of interference, no ground to interfere with any finding recorded in mutation order. Actually, finding of civil suit probate proceeding will have to be acted upon. That's without subsequent. This is without an order. It's without, there's no clear issue. Mr. Banerjee says that if and when, my lord, we all hope the time shall come when Mr. Ghosh, my lord, we shall try to persuade him, then, my lord, we'll cite this order.
Generation that suffered, I don't want
I think that is right. I heard it.
I was before
His father may not agree. What to say.
The best. Out of all three states.
Actually, in this court room, number 4.
The number 9.
No, he used to take residuary writ petitions.
I should walk out.
No, this court also. We used to do electricity. 13 Act hadn't come in. And the residuary judge, my lord, used to decide disconnection writ petitions. Standard order was 50%. Monday morning could be 60%. Friday afternoon could be 20%.
20%.
20%.
You had to see.
I want to follow the same.
That corporation, my lord, is to be heard. My lord. The main, yes.
Whatever I had to say, I have.
And his
paragraph 4
of his affidavit.
Of your affidavit.
Now, please see corporation's affidavit.
Discovery has submitted. Is already there in my paragraph 4. If your lordship kindly takes 5.
Just.
It's a continuation of paragraph 4. Paragraph 4 starts at page 3. If your lordship takes up page 5, page 4 starts at page 3. If your lordship takes page 4,
Yes.
third paragraph, the mutation proceedings. In mutation proceedings, corporation is prima facie not concerned with the title. That is what Mr. Chaudhary was submitting. It only records the name of the person liable to pay property tax. Hence, the prayer being A2 of the writ petition cannot be granted by KMC as it not a civil suit. He wants to record his name as an owner. Whether he is owner or he is an occupier, it's not my concern. I am concerned with the person who would be readily paying my tax. Then, accordingly, both the parties before the Honorable Supreme Court have filed 2 suits, that is Kumar's and the petition. I have given the reference of the suits. Inter alia praying for recovery of khas vacant peaceful possession of the property and title suit number so and so filed by Devashish Kumar praying inter alia a decree for declaration of absolute title over the property by virtue of adverse possession. This is what Mr. Chaudhary has submitted. Thereafter, Malad would kindly turn over to page 5.
Yes.
Moreover, it is the settled principle of law, as it has been reiterated by the Supreme Court as well as the Honorable High Court, that mutation entries in respect of any land or revenue records do not create or extinguish title, and the mutation entries are only maintained for fiscal purposes to ensure the land revenue is paid by the person in whose name it is recorded thereon. Those are the ratio of the judgment cited by Mr. Chaudhary. Then, Malad, though the Thika tenancy right of the Kumars in respect of the premises has been clearly negated by the Supreme Court with a judgment dated so and so, changing the assessment records of the KMC during the pendency of the title suit between the Kumars and the petitioner hearing in the factual background that an objection has already been submitted by the on behalf of the Kumars. Then, my lord, this is my most respectful submission before the court. In the circumstances, answering respondents are duty bound to implement and or carry out any and every direction of this honorable court. As your lordship directs, we will proceed accordingly. I only want my revenue secured, and it comes uninterrupted.
The possessor is giving him the money. If he wins, he'll get his name. He just wants an order to go and show Alipur Court. High Court has said this in some order. Therefore, you know, I have a great case.
I always thought that I had a better case than that. I don't have to rely upon an order directing restoration of my name.
You would not, but your counterpart would misconstrue it before us.
Everybody knows that mutation doesn't really grant any title to anybody. This is a settled proposition of law.
I'm grateful for that.
Anything else, Mr. Kumar, Mr. Khan?
I'll just add a few things. Lord, my learned friend says that he has a title dispute in respect of the property.
Yes.
Lord, I request your lordship, Lord, to kindly have a look at this, the judgment of the Supreme Court once. Lord, it starts at page 114.
Yes.
Lord, paragraph?
Which paragraph you want me to see?
60. Kindly, Lord, come to page 130, paragraph 60. It says, moving on to the Act of 2001, High Court held that even thereunder the landlord's interest never vested in the state. In this regard, the court examined the provisions of so and so. Now, Lord, please come to the underlined part of that paragraph. It is a quotation from the High Court judgment. Lord,
that's the expression.
Yes, thus the expression that is dealing with section 214 of the Thika Tenancy Act. Just after that,
yes,
it says thus existence. Has your lordship got that?
Yes, thus existence of
a Pakka structure on the said land on 1st November 2010 will itself be of no help to the private respondent, inasmuch as on 1st November 2010 there was no subsisting lease in and or contract under which original lessee were liable to pay rent to their landlords in respect of the land comprising in the premises. The lease dated 15th December 1973 expired by a flux of time on 30th September 93. After expiry of the said lease, the lessees became trespassers, and or at best they may be regarded as tenant by sufferants who had no liability to pay rent to their landlord, either under the lease which stood expired in 1993 or under any other law. Thus, the first part of the requirement of section 214 of the Act is not fulfilled in the instant case. Lord, may I just pause here for a moment? 73, Lord, the persons, Lord, interveners, they were, Lord, inducted in the property by the erstwhile owners as lessees for a period of 20 years. So, Lord, 20 years lease expired in 1993. Now, post 1993, they filed an application before the Thika controller for determining their status as a Thika tenant. They were not, Lord, exerting any right or title in respect of the property as against the owners. They never did that. They wanted the property to vest in the state. So, Lord, its title tussle became between the state and the, Lord, the erstwhile owners. The property was transferred to me. Once the property is transferred to me, and before, Lord, the ticker tenancy recording took place, I applied, Lord, with filing appropriate form A42. And Lord, my name was recorded, mutated, and I was given a mutation certificate. But what happened is, the moment the ticker tenancy is recorded, Lord, the state was held to be the owner.
Correct.
Obviously, Lord, the name of the ticker tenant came in to the records. Now, Lord, my name got struck off without even notice to me, because, Lord, the declaration, by reason of the declaration by Thika controller, automatically, Lord, the state became an owner. Now, Lord, I try to restore my title by fighting it up to Supreme Court. Supreme Court, Lord, accepts the finding of the division bench of the High Court that they are trespassers. Post expiry of the lease, they are trespassers. At the highest, Lord, tenants at sufferance. Now, Lord, my right is restored in respect of the property. On that, I apply to the municipality, please restore my name. The form and other formalities were all duly complied with. They are in the records of the municipality. Based on that, my name was mutated. Now, Lord, just one sentence, Lord, on the ownership. Your Lordships may kindly take section 183 once. Kindly take 183(1). It says, whenever the title of any person to any land or building is transferred, such person, if primarily liable for payment of property tax on such land or building, and the person to whom the title is so transferred shall, within 3 months after the execution of the instrument of transfer, or after its registration, if it is registered, or after the transfer is effected, if no instrument executed, give notice of such transfer in writing to the municipal commission. So, Lord, one just can't say that, Lord, I can apply for recording of my name by reason of me being a trespasser in a property, for being, Lord, my name being recorded in the municipal records. I can't do that. That's not permissible. Right. So one has to show a devolution of title to the property by reason whereof the name can be mutated. And your Lordships will find 183(3). The notice under this section shall be, no, sorry, I have placed. 5, kindly see 5. The municipal commissioner shall, on receipt of a notice of transfer or devolution of title under this section, record such transfer or devolution in a book and also in the municipal assessment book, subject to payment of arrears of tax dues to the corporation on account of transfer, etc. So, Lord, up to a particular point of time, when my name was recorded, the Kumars were paying the tax, then I was paying the tax. There was no difficulty on that. But, Lord, the moment their name is inserted, qua Thika tenant, Lord, now that Thika tenancy is gone, they are saying that we have acquired title. Why? Because I have filed a suit for adverse title. Now, Lord, 2022, the Supreme Court judgment, which quoted the division bench judgment, clearly held that post expiry of the tenancy, you became a trespasser, or at the highest tenancy in sufferance. Lord, that particular, Lord, those persons, after the Supreme Court, Lord, passed the order, now files a suit that our status has changed to adverse possession. Now, your Lordships have seen on the other day, I had placed post Supreme Court judgment, there was a review petition which was dismissed. There was a curative petition which was dismissed. That your Lordships have taken. I am not repeating myself. So, my Lord, question today is there a title dispute? Because all these judgments, Lord, that has been cited, they are on a principle where, Lord, ownership is claimed, or, Lord, some kind of a title is claimed in the land.
Property citers.
Today, merely because, Lord, a person has filed, Lord, a suit which may or may not succeed ultimately, that can't be the basis.
Initially, the mutation was done in your name.
Yes.
if we look at 183(1),
Yes.
it is based on the title or
Yes.
the devolution, whichever way it
Correct.
has come.
Correct.
So they had already done that.
Correct.
Later on, since the property was declared to be a Thika tenant property, then probably their name has been, and you are seeking correction of that.
Absolutely. I'm seeking
So
restoration.
we are not getting into the title dispute.
Absolutely not. Absolutely not. And I'm saying, Lord, this issue was not necessary, is not necessary for your lordships to go into, because in fact, the municipality in its affidavit clearly says, after stating all this title dispute and all, it clearly says that we are willing to carry out any directions that your lordships may pass. And I'm saying, Lord, I'm entitled to restoration of my name. Why? And any person, if your lordship looks at section 183, to claim his name to continue as an owner or as an occupier, one must show that there is an authority for the person to continue with the status.
We have read 183 in different ways. Thanks to Mr. Mukherjee and you, both of you.
Lord,
even as an auction purchaser, in lot of context, we have read 183.
Lord, that auction purchase case, of course, is totally different. But
absolutely, but I'm just saying that 183 we have read in many perspectives.
What is important is that I agree to that those decisions, line of decisions where one says that it does not decide title. It's not supposed to decide title.
Correct.
But not at the stage of mutation.
At the stage of mutation, yes. In the sense, at the stage of mutation, when they're initially granting you mutation, they have to rely on a document, which is your title or whichever
Some
it
right.
has some right which has accrued to you.
Absolutely.
And which had initially been done.
And
here.
that right has not been nullified as of date. My conveyance holds good, stands firm insofar as my right in flowing out of that conveyance. So, Lord, today nobody can say that that document is not in existence. That may not be in existence when my learned friend gets a decree in the suit that he has filed, if he at all gets a decree. So, Lord, today, Lord, there is no title dispute between the parties. And your lordships may kindly have a look at these judgments that my learned friends have shown, that each of them had, Lord, a title dispute. To start with, Lord, may I just show that 2017 judgment that my learned friend showed. That's the first judgment. Please take paragraph 2.
Yes.
The material facts of the case are briefly that the petitioner claims to be the owner of premises number 2, Chowbhaga Road, Kolkata, having purchased the same in a court proceedings. The petitioner relies on extracts from the assessment register of Taliganj municipality in respect of his claim of ownership in respect of the said premises. The petitioner applied for mutation of the property in his name. In view of the inaction on the part of the KMC authorities, the petitioner moved writ petition in this court, which was disposed of by an order dated 25th November by directing Municipal Commissioner KMC to consider and dispose of the writ petitioner's representation by reasoned order within 4 weeks from the date of communication of the order. Alleging non-compliance with the said order, the petitioner filed a contempt application. In the said contempt application, the Municipal Commissioner filed an affidavit disclosing an order dated 22nd February 2005. The operative portion thereof reads as follows. It's rather difficult for the municipal authority to identify number 2 Chowbhaga Road without proper demarcation by survey passed by the commissioner appointed by authority of law. This authority undertakes to mutate the name after demarcation of the property and production of registered rectification deed. I once again find it difficult to come to a conclusion in granting mutation in favor of Sri Bimal Kumar Ghosh until and unless demarcation is taken place under the authority or appropriate court, or the registered deed of conveyances are rectified by the appropriate registering authority. And then, Lord, your lordships will find the main problem was that, Lord, there was no demarcation. And your lordships will find, kindly come to paragraph 37 now.
Yes.
At page 3 of the report, it is stated inter alia as follows. From scrutiny of records in KMC assessment register, it is revealed that premises number 13 Chowbhaga Road, etc. Dag number such and such, but not dag number 994. Has your lordship found that? And then premises number 2, Chowbanga Road, covered Dag number 994, so and so, which does not figure in the petitioner's deed of sale.
Thus, there appears to be utter confusion.
Thus, there it should be, appears to be an utter confusion as to whether Dag number 994 is a part of premises number 2, Chowbanga Road, or part of premises number 13, Chowbanga Road. Even the KMC authorities are not sure. So, Lord, this is the dispute.
And both produce registered deeds of title. 39.
And paragraph 39, Lord, your lordships will find that both produced the sale deeds. And that is the reason last sentence it says, hence, prima facie, the sale deeds in favor of respondent 9 shall prevail over the sale deeds in favor of the petitioner. So there was a dispute with regard to a particular Dag, whether it belongs to X or Y. There was a clear title dispute in this case. Lord, none of these cases, your lordship would find that there is a suit filed for a declaration that I am in adverse possession, and that becomes a title dispute. That can never become a title dispute. And just two things, your lordships may kindly, your lordships have taken note of that. The mutation certificate is at page 46. I had shown to your lordship.
Yes.
And then, Lord, the judgments of the Supreme Court, Lord, are there, Lord. Originally, the SLP filed by the tenants were allowed. Then, Lord, a review petition was allowed by the Supreme Court. And then ultimately, this judgment at page 114 was filed.
Yes.
And then the review was dismissed. That is page 147.
Yes,
and the curative is dismissed.
Just one sentence, Milord. Why these changes
reply to
happened?
reply.
Why these? He's finished, Milord. Why these changes happened?
I have finished, but I think
just one sentence.
you didn't.
Why these changes happened in the municipal record? None of it is before the court.
Certainly.
He's not annexed. Municipality has not.
Municipality is not denying that. My writ petition, municipality has filed an affidavit. They are not denying in the fact. It is not the case of the municipality that just because, Lord, they were not because they are ticketed.
Right.
What possessory right?
All for the records. You
Trespassers possessory right. Yes.
No one is disputing it. Municipality is not disputing that they have rectified or they have changed. Your name is there now at present.
State's name was brought in after the first change, and who is in possession, his name is there. Now, my lord, for this to go out and his name to come in, you're actually, destroying my ownership and putting in his ownership.
But if this argument holds good, then every trespasser will apply to the municipality for recording their name, Lord, in the records of the
possession.
Trespasser in possession. On expiry of lease, a trespasser in possession will apply, and their name will be recorded.
Should have applied for my eviction. I don't think we should take more time.
Congratulate Mr. Chaudhary. He has argued well over nothing.
It's a
Mr.
compliment.
Banerjee has now decided.
No, that's not a. It's a compliment.
It's a compliment.
Not a left-handed compliment.
No, left-handed, right-handed.
It's a genuine compliment.
You argued well over nothing.
Or we not argued badly over a lot.
So at least I got the opportunity to hear you, Mr. Chaudhary.
We want you to take up our commercial division.
I go with what he said. I'll go with Mr. Ghosh.
That is only for us.
How many generations you want to suffer?
No, but it's not. We keep disturbing your lordship once your lordship takes that.
Heard, CAV.
Okay.
We finished 22, na? 23 se shuru.
23, I appear for the petitioner.
We are for the Kolkata Municipal Corporation, madam.
My lord, the petitioner has been constructing, my lord, a G+2 story, it has been sanctioned by the corporation, my lord.
Yes.
Now, my lord, the corporation alleging that there are certain deviation, my lord, issued as notice under section 401. Now, my lord, the petitioner received invitation as a developer, my lord. Now, the petitioner came to know that, my lord, the corporation has invoked 408, my lord. Now, my lord,
They are, my lord,
But
attempting.
today you don't have any record. You have come before time.
My lord, but
What
my lord,
is there that
408 modern, my lord, subject to correction, my lord, it is not served
But
upon us,
I-
my
I-
lord.
Kindly say paragraph 10. Only there is apprehension, my lord, has come.
No, but are you doing it? Because he's right to the extent that in 408 you don't serve him a notice.
We have not done my instruction was yes.
I'll record that instruction and I'll dispose it off.
Apprehension, but only see the statement there. Kindly
they-
paragraph
they-
10, my lord,
if
receive
they alle-
information.
If they allege
Sir,
that it
I
is-
also asked the same question, but in 408 you will not serve him any notice. It's an emergent provision which you invoke and you just pass a demolition order.
My lord, and one fine morning they will
If
come
you are
and-
not doing it, there is no problem.
Not
I'll-
possible. We have not done my instruction, my lord, just today. Over instruction, my lord, we have not taken it.
I'll record that. I'll dispose it off.
And my lord, if my lord, they let them take under 401, my lord, they can, my lord.
That I can't.
My lord.
I'm not running the corporation that I will decide 401, 408. Today, you have come on apprehension. That apprehension is not correct. There is no order which has been passed under 408.
My instruction is under process. My instruction, my lord.
And my lord, I would again take the opportunity to, my lord, mention, my lord, if they proceed under section 400, let them at least let us know, my lord. so that,
Nobody
my
gives a notice under
lord,
408.
that is, my lord, the whole difficulty, my lord.
Then you challenge the order if it's passed.
Has not received any notice, my lord.
Take down. The petitioner is filing the present writ petition on the apprehension that the respondent corporation has passed a demolition order invoking section 408 of the KMC Act at premises number 55, Maudidul Islam Lane, PS Beniapukar, Calcutta. It is the case of the petitioner that he is the owner of the above mentioned premises.
He is a developer, my lord.
I am a developer.
The petitioner is a developer, and it is the case of the petitioner that he is the developer of the above mentioned premises and had obtained and is constructing,
Well,
the owner would have obtained the sanction plan
Sanction plan, my lord.
and is constructing the premises in terms of the building sanction plan for a G+2 storied residential building. Full stop. He further states that the owner had obtained a building permit number 202-306-0051 dated 11/10/2023. Full stop. In order to develop the said premises, he had entered into an agreement with the petitioner, development agreement with the petitioner dated 1/7/2024. Full stop. He further states that he for 401 notice has been issued.
Yes, yes.
401 has been issued.
He further states that that a 401 notice under the KMC Act
In August 2025.
has been issued. Though, have you been given a hearing?
No, my lord.
Has been issued. What is the 401 notice? Only to the extent of work stop notice?
Stop construction, all works including
Stop construction, my
Has
lord.
been issued, and he has filed the present petition on the assumption and belief that the respondent are contemplating action under section 408 of the KMC Act. Full stop. Learned counsel for the respondent, Calcutta Municipal Corporation, Mr.
Fajrul Haq.
Mr. Fadul Haq appears and states on instruction from his client that they have not passed any order under section 408 of the KMC Act.
Well, for the KMC, you are not state, for the Kolkata Municipal Corporation.
For the KMC?
For the KMC.
That's what I'm saying.
Yes, sorry. but I
Appear
have-
for the KMC and has not passed any order under section 408. Neither any proceedings have been initiated under
My
408.
section not yet, my lord.
Neither
Lab.
they have initiated any proceeding under section 408 as on date. Full stop. This court finds this petition to be premature and
is thus dismissed with liberty to the petitioner to approach this court in accordance with law if at the appropriate stage. At the appropriate stage.
My lord, I am for the petitioner, my lord. My lord, pursuant to the leave granted, I am moving this matter. Watching the matter is appearing. My lord will kindly take, my lord, I am challenging the change in the nature of use of the ground floor of the property. The petitioner is a one-fourth co-sharer in the property. My lord, there are civil dispute with the private respondent, my lord, with regard to the common areas. There is an order of the civil court. My lord, I am not paying any relief in respect of the matters which are subject matter of the civil in the title suit. My lord, all I am seeking today, all I am challenging is change in the nature of the usage of the ground floor. I'm restricting my submission to the ground floor, your lordship. Lordship will kindly take page 41. That is the IV book.
41.
Page 41.
Yes.
My lord, kindly, my lord, they might not be legible. If I'm
not legible.
My lord, kindly, I'm handing over a better copy. This is the IV book. আরেকটা copy আছে? পরিষ্কার copy?
Yes.
My lord will kindly take the column number 25, last column on the right hand column.
Yes.
My lord, this is a Suomoto assessment or change in the usage made by the Kolkata Municipal Corporation. Lordship will
Honestly,
kindly,
I can't understand this. Suomoto, what is there?
with effect from 2/22/23 under section 178(3), read with section 174, 1 IK and J and 182A of the KMC Act
1988. Approved by
CSC dated 24/9/2022. Now, Lordship have seen that it was made Suomoto. Lordship kindly mark the word Suomoto.
Yes.
My lord, Lordship will kindly thereafter come to the same page, same notice. This is the reassessment. Lordship will kindly take page, the middle of the white portion is there after below column number 1, 2, 3, 4, 5. Well, there are several handwritten, there your lordship will find 185 notice received.
Yes.
But we are not aware of this person who had received this notice. Well, lordship will find the name of the petitioner, name of the item number 5. Column number 5, the petitioner's name is recorded. And suddenly, lordship will now see that just after that, the name of Indrachand Gupta, who is one of the private respondent, his name is reflected over there as the person liable to pay tax. Well, the change your lordship will find from column 14, whether there has been any change. Now, lordship has also recorded the date mentioned in the last column at page 20, column number 25 to be 24/9/2022. That's the date of the inspection. But may I just now, lordship, take your lordship to page number 58. This is a reply. Well, may I just take first your lordship to page 38. That is my letter dated 26th August 2025. Lordship will kindly come to, I'm not reading the entire letter, my lord, kindly come to page 39. The relevant portion, I just first paragraph. Paragraph It has come to the notice of my client that your department has suo motu changed the character of the ground floor of the property from residential to non-residential without obtaining my client's mandatory consent as a co-owner as required under law, and neither any notice or opportunity was granted to my client before this change was effected. Further, next paragraph, it is pertinent to mention that the conversion of the property usage from residential to non-residential requires the explicit consent of all the co-owners, and hence my client's consent is legally mandatory before any such change can take place, and hence such alteration in the character of the ground floor is a breach of the procedure of fairness. Well, now kindly come to their reply at page 58.
Yes.
My lord, the reference is to my letter which I've just placed 26th August 2025. With reference to your letter above, this is to inform you that the nature of use of the ground floor of the subject premises has been changed from residential to non-residential on the basis of a declaration given by self-assessment form by co-owners and certificate of enlistment issued to Sri Kailash Company at the said premises by so and so. Beside inspection conducted by the officials of the ACS department on 24/9/2022, that is a date Lordship I've mentioned in the IB book. Also confirm the existence of the said establishment at the ground floor of the subject premises running restaurant. Therefore, in exercising the power conferred under 182 of the KMC Act, we are duty bound to record the existing use and give effect to the assessment according to which, however, does not regularize any unauthorized use, if at all within the meaning of subsection 1 of 416 of the KMC, which is under the purview of the building department. Now, they put this department, put it to the building department. There is no reply after that. Now, what is happening? Now, based on this change of usage, the private respondents are letting it out for commercial purpose. My lord, that photographs I have annexed at page 59 and 60. My lord, my letter of 26th of August is till date not answered in totality. My lord, I can show that the per se contradiction between the IB book and the letter issued, my lord. Lordship has seen that based on the self-assessment, the letter they write to me on 6th of September is based on a self-assessment. And in the IB book, it is suo motu. Lordship will kindly take 185 of the section 185 of the Act, which clearly makes a distinctive features with regard to a suo motu inspection and a self-assessment. If my lord kindly take 185A, make suo motu assessment in any case where a return on the basis of the self-assessment has not been filed. So, yes. I apologize.
Yes.
My lord, will take 185A. Make suo motu assessment in any case where a return on the basis of self-assessment has not been filed. So, suo motu can be made when the self-assessment has not been filed. B, revise any assessment where the information furnished in the return of self-assessment is found to be incorrect. So, there are two aspects. One is on the basis of a self-assessment, one is suo motu. One hand there in the IB book, they said it's a suo motu. On the second hand in the letter, they write it to be a self-assessment. That is one of the ground. My lord, today I am on two parts. My lord will kindly see that I have an order of there is a persisting dispute with the private respondent. I am not getting into the civil dispute part, but lordship will kindly see no notice was ever received by me with where I could have really pointed out that the ground floor was always a residential property. But I am a 1/4 co-sharer in that property. There is no doubt. Without my consent, without there being any partition, that particular ground floor without my consent the change of usage could not have happened. But at 416, now the private respondents are trying to let it out for commercial purpose. I have annexed those pictures. But all I seek, my lord, is kindly my lord, to cut short the matter, my lord, all I seek today is let the municipal commissioner under the provisions of the KMC Act give me a hearing, consider my representation dated 25th of August 2025. And in the meantime, my lord, my lord, no commercial activities or the change of usage that has taken place should be kept on hold. That's all I'm seeking for the timing. Let the municipal commissioner hear me out, give a notice of hearing. I will produce all my documents. Some documents are not with me. If they want to rely upon any parties, they will supply me copies, or I can take copies from the certified copy from the book, my lord, and hear it out. In the meantime, only, my lord, for that limited period, whatever time your lordship fixes, I'm only praying for a limited protection.
Yes.
Lordship, keeping the civil suit pending, how far this writ application is maintainable?
It is maintainable, madam.
That is a question, because your lordship, if my lord comes to the order of the title suit, page 53. Page 53, my lord, it comes to the third paragraph, may be permitted to place
I
that.
just want to know one thing. How can you change the property without the consent of one of the owners?
Lordship, the entire record has not come up, but the point is, when a status quo was there in a civil dispute, that status quo was obtained in the year 2022 in a civil order. Lordship, the thing is that without coming into the writ jurisdiction, what the next orders ought to have come up in the civil code, that has to be looked into. Perhaps my learned
I have only one simple question.
Lordship.
How have you changed the
Lordship, that
usage?
For that, the record will has to come up. For that, Lordship, if my
Get the record till the time don't give effect to the conveyance order.
But your lordship, this writ application keeping the maintainability of the writ petition.
I will satisfy.
The civil
Rate is maintainable. I'll decide it. Rate is maintainable.
Because your lordship, keeping the civil suit pending when the same issue.
Civil suit has nothing, madam. Civil suit has got nothing to do with this.
It's got something.
As of today, he is also a part owner.
My lord, if my lord come to page 53.
Yes.
Third paragraph.
Yes.
The contention of the plaintiff is that the plaintiff and defendants are the brothers and joint owners in respect of the entire premises of such and such is called the suit property, having undivided 1/4 share and part each. The suit property was duly purchased by the plaintiff from Kamala Rani and such by separate 4 registered deeds. The plaintiff is in exclusive possession of the entire third floor of the suit premises. The defendant number 1 resides in the second floor of the suit property, and the first floor of the building is occupied by the defendant number 2. And for the business purpose, he used to come to Kolkata, but actually residing in Tamil Nadu. And the ground floor is occupied by defendant number 3 for residential purpose. Now, this is his challenge. But without taking property permission from the plaintiff, shifted the brand South Indian restaurant, namely Super Snacks Bar of SKT Ganapati Healthcare Private Limited. A family-run, closely held company in the ground floor of the said premises have forcibly occupied a portion of the common area in the ground floor to make a kitchen. This was all the subject matter of the suit proceeding, your lordship. Now, your lordship, if my lord kindly come downward, your lordship. The kitchen of the said restaurant did not pay any heed to the plaintiff's objection to it. Plaintiff and defendant and joint owners of the said premises. The plaintiff has every right to use and enjoy the common areas and common facilities. Unfortunately, defendants and his main associates are constantly this is the subject matter of the suit. What is the subject matter of the writ petition? Now, your lordship, if my lord kindly come to the operative portion of the order, your lordship, that page 54. That both the parties are directed to maintain status quo in respect of the nature, character, possession of the suit property as on today till 5th August 2022. Lordship, the question now arises, what happened after 2022? So if there has been some violations,
even if you look at this, if you look at this order, madam, you should have not changed the property from residential to commercial.
Lordship, to that effect, we can go for the inspection and we can see to it whether there has been a change of nature of change in use or not. But in the representation, your lordship, his allegation is twofold. One is unauthorized construction and another is the change of use. Now, regarding the change of use, that has been taken care of in the civil suit itself. Yes. So, twofold jurisdiction, it is also barred by res judicata, your lordship. In this particular matter, your lordship.
Not at all.
Because this after 22, what happened, your lordship? Nothing has come up before.
After 22, if you follow the order, you should have done nothing.
Lordship, for that I may file a report, your lordship, after giving the inspection whether there has been a change of use.
You should have done nothing about it.
But keeping the question of maintainability of the writ petition.
No maintainability of the writ petition. The petitioner has preferred the present writ petition.
The suit is pending regarding the same issue, your lordship.
It is not the same issue, madam.
Lordship, the order, the
Order
text
doesn't read that.
like that.
My lord, I can show the prayers, my lord, at page 15, which I
Why have you not annexed the other orders? Why you have annexed only this order?
I am restricting, my lord.
What is the current order which is there? What is the status of the?
This order has been extended, I have been told. My lord, but
where is?
My lord, may I just indicate?
Yes.
My lord, this order persists to the common area. My lord will kindly come to, my lord, certain queries have been put forward. I'll answer.
See, as far as this property is concerned, it has been divided between all the brothers.
No partition.
That is pending.
No, this is not a suit for partition. The suit that I'm relying up, the order which has been passed is not for a partition.
What are you seeking?
My lord, in the suit.
Yes.
Lordship, that is there in the first paragraph itself. Plaintiff, by filing this application, has prayed for restraining the defendants not to obstruct the plaintiff and his men and agents and associates from enjoying the common areas, common
My
facilities.
lord will kindly come to page 15, paragraph 32. I have set out the prayers. Page 15, paragraph 32, 15.
I have not filed it.
My lord, I'll put it by way of a supplementary. I've set out the paragraph. My lord, I have clearly made a statement that kindly have a look at the.
Clearly made a statement. Nothing is clear.
Lordship, rest of the orders should come up on
My lord,
record.
kindly see that it is restricted to common areas and common facilities and lift as well as the roof. I have mentioned
Where have you?
Rest of the orders, my lord, we will inspect, but rest of the orders should come up from 2022 to 2023.
Yes, I will put it by way of an. My lord, I am only on a very limited. I am not getting into any question which.
I will not grant you any stay till the time you put everything on record.
My lord, I put it. My lord, I have the copy of the plaint. My lord, I have.
But you should have filed.
My lord,
not like this.
It was prepared. My lord, I have obtained a leave.
Whatever it is.
My lord, I'll put it by way of a affidavit within the course of the day. Within the course of the day, I'll put it.
Not at all. Let them file their report. I'm not staying.
My lord, Lordship will kindly see what is happening at page 50.
Nothing.
My lord, Lordship will kindly see at page 50. There is a.
I can see that what is happening.
My lord, Lordship can see that what is happening. I am a 25% co-sharer in a property, undivided property.
All right, take down.
My lord, all I seek, my lord, let them file report. I have the plaint.
They will file report.
My lord, let them file report. I was seeking for a. My lord,
the petitioner has preferred the present writ petition, challenging the conversion of the ground floor and common area of premises number 513A, Block M, New Alipur, Calcutta, from residential to non-residential. It's residential to commercial or non-residential? How do you?
Residential, originally it was residential.
Residential to non-residential.
That is their allegation.
Non-residential. Non-residential use, full stop. The case of the petitioner is that he, along with his brothers, respondent number 7, 8, 9, are co-owners of the aforesaid premises, full stop. The said premises is a residential building, full stop. The common areas, including passage, staircase, and open spaces, are meant exclusively for the use and enjoyment of the residents. The grievance of the petitioner is that respondent number 7 to 9.
7 to 9.
7 to 9, in connivance with the official respondents and without the consent of the petitioner, have, in gross violation of the sanctioned building plan and municipal laws, undertaken / allowed the ground floor to be ground floor and the common portions of the premises have allowed the ground floor and the common premises, common portion of the premises for commercial and non-residential purposes, full stop. Based on the complaint lodged by the petitioner, respondent number 4, by letter dated 6/9/2025, confirmed that the property has been inspected on 22/9/2022 and had been converted from residential to non-residential on the basis of consent allegedly given by the co-owners.
The date will be 24/9.
24/9/2022. Full stop. Allegedly by the consent of the co-owners. The petitioner has further The petitioner contends that such conversion was effected without his knowledge or consent and is therefore illegal and arbitrary. Full stop. The petitioner states that the official respondents have suo moto done the conversion, and the consent of the petitioner, which is a mandatory requirement under section 185 of the KMC Act, has not been followed. Full stop. The petitioner further observed that the petitioner further states that the respondent number 7 to 9 are carrying out alteration in the said building without permission from the respondent corporation and are planning to lease out the converted premises to Tata Starbucks.
Tata Starbucks for commercial.
Tata Starbucks Private Limited for its
I have a better picture.
for its commercial usage. Full stop. Being agreed by the illegal and arbitrary conversion of the ground floor and the common areas from residential to non-residential use, comma, and by the inaction of the respondent in addressing his grievances, comma, the petitioner is constrained to file the present writ petition. Full stop. Learned counsel for the respondent seeks and is granted 4 weeks time to file affidavit in opposition. A reply to the same, if any, within 2 weeks thereafter. List on.
My lord,
You get them place the subsequent orders also, Your Lordship. That is my humble
I'll
prayer.
place it in the reply.
Nothing has come up on it.
Learned counsel वहाँ ऊपर लिख देना है जहाँ affidavit के पहले. Learned counsel for the respondent states that the petitioner has withheld material information and states that the order which is and the petitioner has not placed all the orders in title suit number 996 of 2022 and has only placed the order dated 6/7/2022. Full stop. She further contends that the subject matter of the title suit is similar to the prayer of the petitioner in the present writ petition. Full stop. उसके बाद करना learned counsel for the respondent seeks and is granted.
My lord, some
Let's start the
protection, my lord.
No.
Kindly see. My lord, ultimately when the writ petition is heard out after 6 or 8 weeks, my lord, they will come, they will let it out. There will be a third party who will, my lord, let them not, my lord, not civil matters, my lord. That will be best, my lord. No steps should be taken by the KMC. I'm not on the private respondent.
Not at this.
My lord, kindly, my lord.
Not at this stage. Not at this.
KMC, if the issue file lies, if the other
Not at
licenses,
this.
that will be clearly in violation of section 421, your lordship.
It will get cancelled if it is in violation.
My lord, let them not create. That someone else will start
Today,
functioning.
prima facie, it can't be done. Not at this stage. Next. List on, give it in November.
Lordship, third week.
After 6 weeks, third week of.
Well, then at least abide by the result of the writ petition. One line that goes.
There's no need to add that. Everything is subject to the outcome of the writ petition.
My lord, even if it is, my lord, at least to my satisfaction, that one line goes through, my lord, at least something I can take back before the.
Everything is subject to the outcome of the writ.
Well, let that everything is subject. Well, kindly
No
that
need.
line.
No need. 7th November.
Third week of November, my lord, if that is permissible. Third week of.
Second week of November.
Second week.
Give it 11th November. 11th November.
Much okay.
Twenty-six. This by application, last occasion, my lord, the respondent, landed council appearing on the respondent municipality come with the instruction by 9-month honorarium has been written. My lord, over that issue. But this
As per
might be
instruction, verbal instruction given by the chairman, my lord, they are going to pay the admissible dues within 3 weeks, my lord.
Then, my lord, kindly
My
fix
lord,
it matter for that, my lord, the compliance, my lord.
What is admissible dues?
It is a contractual worker, my lord.
Yes.
They are working under the ASHA scheme. My lord, they are working on the 6 months or 7, কত মাস জানো?
9 months.
And 9 months, my lord.
You agree to the admissibility?
Yes, yes, that is my prayer. That is my prayer.
We'll dispose it off.
My lord, kindly, can it be, my lord, for the report? My lord, as your lordship, as your lordship. My lord, kindly direct them as per their instruction, they will pay me within certain time.
Within what time period?
My lord, my lord, last week of October or first week of November, my lord. Because the holiday is starting from the municipality is from 26th, my lord.
Yes.
26th to middle of October, my lord.
In terms of my prayer, my lord, I have specifically mentioned.
What workers are you? HHWS?
Honorary health worker. The ladies are, my lord, working for polio, etc., for the social work that has been, my lord, engaged by the fund has been provided from the, my lord, Urban State Development Authority.
The petitioner has preferred the present writ petition seeking disbursement of financial benefit for the period of 9 months with effect from June 2022 in favor of the petitioner against rendering the services of honorary health workers with the respondent corporation. It is the case of the petitioner that she had joined as honorary health worker at the sub-center. Which is the sub-center?
My lord, under the Uttamara Kotram municipality.
Jaisabad on 11/1/2019. It is a case that even after 3 years of the said appointment, she has not been paid the.
Well, he has the contractual worker after 2023.
He has not been paid the honorarium. Full stop. Being agreed by the non-grant of honorarium, the petitioner had submitted a representation dated 11/1/2023, however, till date no response has been received. Full stop. Learned counsel for the respondent, which is
Uttarpara Kotrang municipality.
Uttarpara
Kotrang
Kotra municipality.
Respond number 8.
Respond number 8 states that they are ready and willing to disburse the honorarium of the petitioner within a period of 4 weeks.
Yes, ma'am.
Within a period of 4 weeks.
The admissible dues.
The honorarium, which is the admissible dues of the petitioner within a period of 4 weeks. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is done within the said period. Full stop. In view of the submission made by the counsel for the parties, this court bounds the respondent number 8 to abide by the statement made before this court on instruction that the said honorarium will be paid within a period of 4 weeks or 6 weeks. 6 weeks. Within a period of 6 weeks. Full stop. Because of Durga Puja, they might not. So within a period of 6 weeks, in view of the said direction, the present petition is disposed of.
I'm extremely.
And and for the petitioner, this is that matter where I was allotted the shop and the allotment was cancelled and the application.
That is the matter when that is the matter where your lordship was lastly taken up, and that my learned friend has, my lord, page number 25 indicated, and my lord, I have submitted that all of full wrong in awardment made in the writ petition, and your lordship was inclined to dismiss that matter. And that point of time, my learned friend has indicated page number 25, and my lord, I have agreed with that, my lord, to hand
6
over
lakhs.
that. Yes.
The refund of 6 lakhs.
6 lakhs,
Okay.
some interest. I was paying for some interest because This
You
is
want
of
your 6 lakhs or you don't want your 6 lakhs? He has got
that-
the check also. Learned counsel for the petitioner preferred the present writ petition being aggrieved by the inaction of the respondent in not refunding rupees 8 lakhs along with 12% interest, which was deposited in lieu of the allotment of shop at Sonar Tari shopping complex at city center, Debhog, Haldia, Purbi, Mednapur. Full stop. This is the second round of litigation between the parties. Full stop. The case of the petitioner is that by a allotment letter dated 6/2/2011, the respondent authorities allotted a shop in the above mentioned marketplace to the petitioner for a period of 99 years, for a lease period of 99 years. Full stop. In terms thereof, the petitioner had deposited an amount of rupees 8 lakhs towards lease premium. Full stop. The possession letter was issued in favor of the petitioner on 19/5/2017. Full stop. Subsequently, while order dated 11/11/2019, the respondent cancelled the aforesaid allotment on the ground that the petitioner was not willing to run business from the allotted shop. In the said cancellation order, it was further stated that the respondent was willing to refund an amount of rupees 6 lakhs after deducting 25% of the deposited premium of 8 lakhs. The petitioner along with full stop. The petitioner at the outset states that he shall be satisfied if the amount of rupees 6 lakhs is refunded to him. Full stop. Learned counsel for the respondent, so-and-so Haldia municipality, has come up with the check of rupees 6 lakhs, which is handed over to the counsel for the petitioner. In view of the said development, nothing survives in the present writ petition. The same is disposed of in the terms that the amount of rupees 6 lakhs has been refunded to the petitioner and his grievances are addressed.
Only one kind indulgence, my lord. 6 lakhs, my lord. Of course, this is an admitted amount. The rest of the amount I can't claim in a writ petition. But since there's disputed questions of facts.
I'm sorry, sir. I'm sorry. If you don't want that 6 lakhs, give it back to him. I'll issue notice. He'll file reply. You file your. Do you want counter?
No, my lord.
Only things is that, my lord, my learned friend has deposited the money in the name of Adarso Hotel and Restaurant. But application filed by Ganapati Maiti, that
he's a sole proprietor.
that should be recorded. Otherwise, again they will come with that.
What will
I'm so grateful, and full and final.
The respondent has handed over a check
My
in favor of.
My lord, that Adarso Hotel and Restaurant.
A copy of the check is taken on record. It is pointed out by the counsel for the respondent that the allotment was done in favor of
My lord, Adarso Hotel and Restaurant.
Adarsh Hotel and Restaurant, though the present writ petition is filed by
Ganapati Maiti.
Ganapati Maiti. Full stop. Learned counsel for the petitioner states that Ganapati Maiti is the sole proprietor of Adarsh Hotel and Restaurant, and that the petitioner is the rightful owner of the allotted shop and thus is entitled to receive the payment of rupees 6 lakhs. Full stop.
I'm so grateful, man. I'm so grateful.
फिर बाकी वैसे ही करता हूँ.
अरे सेटा तो full and final settlement तो what ही. Is it required to record that while no further claim to be made? My learned friend going to be again.
Learned counsel for the stands satisfied. The grievance has standard, and the petitioner shall not claim any further damages from the respondent Haldia municipality as far as the allotment of the
as far as the cancellation of the said allotment of the shop is concerned.
I'm so grateful, ma'am. I'm so grateful.
Or premises number 90 is a big plot. Malad is a center city road. Malad, initially, as per Malad, the master plan prepared in 1930, there was a pond. But Malad, there was a building, Malad, all the joint owner, Malad, we were residing there. Malad, and premises 90 divided into Malad A, B, C, D, E, F, 6 Malad says.
Yes.
Malad, all A, B, C, D, E, well, already municipality sanctioned the building plan for construction the residential building. In respect of my, Malad, I file an application. Malad, they raised, refused to pass the sanction the building plan on the ground that Malad, in 1913, the master plan, there was a point. Malad, kindly see, Malad, in respect of another premises, Malad, the same point raised by the municipality, Malad, our High Court passed an order to consider this case.
That is what he's asking, Mr. Mukherjee, parity with the.
Let the application be considered in the light of that judgment.
Judgment, Malad, page 24.
That's the only highest he can place his case.
This is also, this order is also passed, keeping in mind earlier writ petition, 2007.
That judgment, Malad, is.
I tell your lordship that so far as the Inland Fisheries Act is concerned,
yes,
it might have been a pond in the records of the corporation. Inland Fisheries Act was, it came something into 1990. Now, before 1990, these ponds were all systematically filled up and constructions came. And though the corporation record says it is a pond. Now, after the 1990 Inland Fisheries Act.
But Mr. Mukherjee, let me tell you, at least in Bengal, you still have these ponds. You go to Bihar, I remember my childhood, there used to be so many ponds. Today, there are none. You are still very lucky to have preserved so many of them.
There's none, I tell your lordship. I tell your lordship, in the locality where I stay, the rain your lordship experienced yesterday,
Yes.
in those type of rains, people will not believe, we used to see fishes roaming around on the road, and all the kids, they are busy with the net, catching fishes, and they used to haul up 1 kg, 2 kg, 500 gram, everyone is catching. So now it's not there. This is no more. There's no pond, and naturally the fishes are also gone.
But
All
still,
the entire Eastern Calcutta,
Eastern Calcutta.
that was the lung of the city. It's all filled up. Promoters, government is also a part to it. That ECTP project, East Calcutta Township project, these are all promoted by government. HUTCO is there, West Bengal Housing Development Board is there. They have systematically filled up these ponds and marshy land, giving rise to the high rise and building. Previously, the water used to pass away from that eastern side. Now, the eastern bypass acts as a barrier. The water is all blocked over here. If the eastern bypass is not there, the entire water would have gone eastwards through these marshy lands.
what is now called Ramsar land and all that. All these are, they used to be naturally watered by this rainwater. It's a government apathy, absolute systematic government apathy for the sake of earning revenue. They have allowed, and now we are facing the brunt of it. Now, this is where, so they were filled, plans given. Now, after 90, some gentleman says, well, this is a pond. But this, whatever has been filled has been filled. So this, the act doesn't have a retrospective effect.
Right.
If it is given, then again the whole Calcutta will be water body, particularly the South Calcutta. Anyway, let that application be considered in the light of the judgment of Lord Justice Tandon, as his lordship then was.
All right. You have already filed the application.
Yes. Right? Page 14, Malad.
Now it is done online.
Online rejected on the ground, the environment and heritage. And on page 13, Malad, this
Rejection
is my
order is? Where is the rejection order?
My rejection order, Malad, page 14, last
Down
column,
below.
Malad, the building. 1-4, Malad, building. Kindly see. 1, 2, 3, 4, 5. Malad, plan proposed building permit, full status.
Reject.
Malad, all are approved. Only, Malad, the proposal requires observation by Environment and Heritage Department.
All right. Take down. Tamal. The petitioner has preferred the present writ petition challenging the impugn order dated 25/6/2022, whereby the petitioner's application for sanction of building plan in respect of premises number 19F, Center Sinthi Road, Santrapara, Calcutta, situated at Mauza, Sinthi, under the jurisdiction of Calcutta Municipal Corporation, was rejected. Full stop. The case of the petitioner is that the subject plot forms part of premises number 19, Center Sinthi Road, which was lawfully partitioned among the co-owners into 6 separate plots, namely 19A, B, C, D, E, and F. Full stop. The respondent authorities have already sanctioned plans in respect of plot 19A, B, and C. Full stop. However, when the petitioner applied for the sanction of the building plan in respect of premises 19F, the same was rejected rejected on the ground that your proposal requires observation from Environment and Heritage Department. Full stop. Aggrieved thereby, the petitioner has approached this court. Learned counsel for the petitioner submits that in an identical matter, being WPA number 23423 of 2017, this court had directed the respondent to release the building sanction plan, observing that since the plan in respect of the co-owners have already been sanctioned, observing that since plans in respect of the co-owners had already been sanctioned without objection, there could be no justification in withholding the sanction in respect of the remaining co-owners. Full stop. The petitioner accordingly prays for similar relief. Full stop. Learned counsel for the respondent, Mr. Mukherjee, KMC, Calcutta Municipal Corporation. Mr. Mukherjee states that the corporation is ready and willing to. You have to
Consider the application in the light of this judgment.
is ready and willing to consider petitioner's application in light of the judgment in WP 23423 of 2017. Full stop. The impugned rejection order is set aside. The corporation is directed to consider petitioner's application in terms of the above direction. Afresh. The writ petition is disposed of.
Within a reasonable time. Within
Afresh within.
within 3 months, 4 months, 3 months.
4 months, ঠিক আছে। 4 months is okay. 4 months means 16 weeks.
Within a period of 14 weeks.
Grateful, man. Much obliged.
Within a period of 3 months. 3 months. Within a period of 3 months.
Lord, I am for the petition.
I am for the state.
What is this can 2, can 1, can 2?
It has not been served, my lord.
Give the can. Can 1 is can 1 and can 2. Can 1 is
can 2 is my can, my lord.
Can 1 is the condonation of delay.
None of the can has been served.
It's been served to me
No,
also.
my lord, only my one can, my lord.
Please give the can at
Lordship,
least supply a copy. They are saying they have not received.
My lord, can 1 is not my application, my lord.
All
Can
right.
2 is my application, my lord.
All right.
That the
Application for substitution.
application for substitution. Recognition. Can 1, my lord, this is not my can. Can 2 is my can. It is a substitution, my lord. But I have given that copy, my lord.
Yes, you have any objection?
And I have to see.
A copy of the application has been. What do you want to file reply or what, madam?
Yes, my lord.
What do you want to do?
My matter is
Lordship, matter.
Learned counsel for the respondent. You are the private respondent.
private respondent.
You are.
I am for the state. Respond number 1.
Lord,
Well,
your
it is
lordship can
joint
dispose that
property
application. my
and
lord.
it has not been demarcated. That is why house for all has been declined by the concerned municipality also, my lord. I'm able to produce the deed of conveyance in favor of my father in the plot number 710, my lord.
Lord, the gentleman who opposed that house plot claim, Lord, Lord, he has not recorded owner of that plot, Lord. Lord, originally, Lord, 52 is the holding number is subdivided into another 2 number without partition deed, my Lord. Lordship,
I don't have any objection.
Lordship,
Wait on, Kamal. This is an application filed by Can2. This is an application filed by the petitioner seeking substitution of the legal heirs of respondent number 5, who expired on 4/7/2023. Full stop. The petitioner submits that he became aware of the death of respondent number 5 while attempting to serve the writ petition in compliance of the directions passed by this court. Full stop. It is further submitted that the present application has been filed within the statutory period from the date of knowledge of his death, of the said death. Full stop. In view of the above, the petitioner prays for substitution of the legal heirs of respondent number 5 as mentioned in para 4 of the present application in his place. Full stop. For the reasons stated in the application, the same is for the reason stated in the application and the concession granted by the council for the respondent number
5, my lord.
respondent number 5, the present application is allowed. The legal heirs of deceased respondent number 5 as mentioned in para 4 of the present application are substituted in place of respondent number 5. A copy this you appear for them also?
My lord.
Are you appearing for them? The legal heirs?
Yes, I will file the
a copy of the all right. the necessary correction shall be carried, necessary steps shall be taken, application is disposed of.
My lord,
Can 2. Can
Only
2
the-
of 2025.
Lordship, the writ petitioner also Lordship can dispose it. Lordship kindly see page 28, my lord. Page 28, my lord. The chairman,
Yes.
the chairman Shantipur municipality issued a notice to my client, my lord. You are hereby directed to come in municipality office on so and so with relevant documents. Law officer, nodal officer will hold a meeting with you and Shankar Pal regarding the dispute arise about the land by you and Shankar Pal. Not that thereafter, my lord, the municipality have no pass any order nor any communication to that order. So we are only, my lord, my prayer is, Lordship kindly direct the municipality to pass that order in pursuance of
Who
that.
appears for the municipality? Nobody is here for the municipality. Which municipality is this?
Shantipur municipality, my lord.
But we have served that
I
order.
have got indulgence.
Two times, my lord, I have served the
All right, sir. They are not here.
My lord, may I? And this is a completely joint property. And my
Lord,
property is
oh,
also
my lord,
there.
this is
My
not
property is also there.
but
And
my lord,
in favor of which proportion
First,
they,
you carry out the necessary correction.
they have got the house
List,
for all.
list after 4 days.
Grateful, ma'am. Can it be fixed on any day, madam?
November.
4 weeks after vacation. 4 weeks after vacation.
29th November.
Grateful.
No, 28th November, sorry.
28th November. Grateful, ma'am.
November.
Grateful, ma'am.
Take down. None appears for the petitioner. Even on 2/8/2025, there was no appearance on behalf of the petitioner. Full stop. It seems the petitioner is not interested in pursuing the present writ petition. The same is dismissed for non-prosecution. Yes.
Your Honor, in item number 31, I'm for the petitioner, Your Honor.
Yes.
Your Honor, I'm praying for not today on my senior's ground. He is terribly ill and he couldn't attend the proceeding, Your Honor.
All right. Proxy counsel so and so appears and states that the main arguing counsel
Your Honor,
is
he
indisposed.
this week because he is very
Madam, are you working next week? Then
after puja vacation. Then Your
that's what I'm doing.
31.
Proxy counsel so and so appears and states that the main arguing counsel is indisposed. She prays for a short adjournment. Let this matter be listed ensuing the puja vacations.
Great.
The rest of the matters tomorrow.
Can be fixed on any date? Every day.
After vacation now. Mr. Badu, after. Tomorrow. And then Friday is the only day where you'll be treating me. Some bar is treating us.
After vacation.